Yes.
Good morning, Chair. May we please call Ms. Rosie Draper?
I do solemnly, sincerely and truly, declare and affirm
that the evidence I shall give
shall be the truth, the whole truth, and nothing but the truth. Thank you.
Yes, I'm sorry we had to get you back again today.
It's okay.
Thank you. Yes, Mr. Avery.
Ms. Draper, you've provided the inquiry with a statement dated the 13th of November 2025. Can you confirm it's true to the best of your belief and knowledge?
Yes, I can.
Is it right you qualified as an adult nurse in 2015?
That's correct.
And you became an HCP, a healthcare professional, in 2018?
That's correct.
And lead senior HCP in 2023?
Yes, that's correct.
Could you just tell us what that role involves as lead senior HCP?
So a lead senior HCP is responsible for the management of senior HCPs and HCPs, and also clinical duties that I would undertake as a HCP.
So there's a management side of it, but
Yes.
also a side of seeing detainees?
Yes.
And had you received training in mental health specifically?
So I don't have any mental health qualifications. However, joining custody, I have completed mental health in custody training.
Is that with Mighty?
Yes.
In terms of mental health assessment, what's the role of an HCP?
So a HCP would attend to the detained person and conduct an assessment, a mental state examination, determine if there were any hallucinations or if there were any areas they had concerns about regarding their mental health, and they would then go from there and escalate.
And what's that with a view to? Is that healthcare planning? Is it fitness to interview, fitness to detain?
So it would encompass fitness to detain, fitness to interview, and then future planning.
If we could have up on the screen, please, NGPF 0007755. This is Nottinghamshire Police Custody Policy. And then to page 98, please. And you see the section at 9.4, the first paragraph, which we looked at with previous witnesses yesterday, but there's the passage stating that the detainees should be assessed by an HCP as soon as practicable after their arrival. They should assess whether or not formal mental health assessment is required and advise the custody officer. In respect of the reference to formal mental health assessment, is that talking about a Mental Health Act assessment or something else?
I would assume that that would be a mental health assessment. If it was a Mental Health Act assessment, I would assume the writing would be Mental Health Act assessment.
And what is the role of an HCP in respect of Mental Health Act assessments?
So during working hours, if L&D are available, then we would escalate our concerns to L&D, who would contact the crisis team with the gatekeeper, and they would then contact the AMP. Out of L&D working hours, then it would be the HCPs themselves that contact the gatekeeper at the crisis team. However, on occasions, because we work in partnership, if workload allows, if L&D, for example, had a higher workload than the healthcare professionals, we would also take on that role to contact the crisis team during their working hours to help with their workload.
So for your purposes, the distinction between L&D and the crisis team in respect of Mental Health Act assessments is really a matter of whether it's in or out of hours and a matter of capacity. Is that what you're saying?
Correct.
And is it the role of the HCP to decide whether a Mental Health Act assessment is required or not? Does that decision lie with you? So
we can advise, and then we would escalate that to the appropriate professionals. If we were escalating to L&D, they may want to go and see that detained person themselves and create their own assessment. Or if we were speaking to the gatekeeper, if it was out of hours, then the gatekeeper would usually come to custody and assess that person themselves.
If that could come down now, please. And if we turn to and have on the screen NGPF 0002378. This is an entry on the 13th of June 2023 at 1:17. It's entered by Holly Bramley, but we see reference to you in the entry as LSHCP Rosie Draper. First of all, it talks about an HCP being asked to complete body mapping in toxicology bloods. Do you recall, without reference to this record, what you were told about that?
From my recollection, the job that was placed to come through was for toxicology bloods.
And who did that job come from?
So that would have been placed on our electronic system. I can't recall who placed that job. I'd have to look at the custody record.
We know from other entries on the custody record, in fact subsequent entry, that bloods were authorised for the purposes of profiling, for DNA profiling, not for toxicology. It suggests there's some kind of misunderstanding or miscommunication that's happened. Do you have any insight as to what has happened there?
I don't recall being asked to take a sample for DNA profiling. Should I have been asked for that, I would have spoken to the labs to ensure that our bottles were the correct bottles to use, but from my recollection, there was no conversation on what was being asked of. It came through as toxicology.
So were different bottles different?
Potentially.
Okay. The next thing we see is that you haven't yet been able to assess VC's capacity. And that's because of his refusal to engage, is it?
Correct.
And at that point, you go to liaison and diversion.
Correct.
Why do you go to liaison and diversion then?
If a detained person is not engaging with me, I would want to information gather, and part of that is to go and speak to L&D to seek out information on his history.
That would be from the Rio records?
Yes, that's correct, yeah.
So in that sense, you're reliant on liaison and diversion for access to those records?
That's correct, yes.
Do you find that a satisfactory system in practice?
Any time that we have requested information, whether that be in or out of hours, we have always been able to obtain that information.
And what about the extent of information you end up getting? Do you think it's enough?
It can be, yes.
We then see in the entry a history of VC's mental health has been provided. What did you make of that?
That he had significant mental health history that we should be aware of.
How did that affect your decision-making going forward?
So I wanted to reassess VC to ascertain if he would engage with me, to ascertain his capacity. It's helpful knowing this information and knowing what his relapse symptoms are so that we could look out for those whilst he was in our care.
Just in respect of this entry at this time, 1:17, is it right you hadn't seen VC at this point?
I believe that I can't recall whether I had seen him and he hadn't engaged and then we went to L&D, or whether we'd gone to gather information.
There's no mention in this entry of you having seen VC explicitly, is there?
No.
If we could have next on the screen, please, NGPF 0002379, page 2. This is a lengthy entry. It seems covering about an hour and a half, 2 hours period of time. What we see first is that physician findings, we see the VC is initially seen in cell with HCP Bramley, and this is an entry by you, isn't it?
That's correct.
And L4 officer sat inside the cell. Again, there's the reference to toxicology, bloods and body mapping, isn't it?
Yes.
So is the purpose for this reattendance to VC to revisit capacity?
Yes, to ascertain if he had the capacity to undertake the toxicology, bloods and body mapping.
And what we see at the beginning of this entry is VC's asked if he'd like to engage. He replies after a pause, no. When he's asked if there's a reason why he did not want to engage, again, he replies after a pause, no. To a question about medication, he responded, no, I think I have said no, not yet. And when asked if he could obtain the samples, he said, no, not yet. And then you leave the cell, is that right?
That's correct.
At that point, you go back to liaison and diversion, is that
That's
correct? And we see an entry here you've made in respect of that. You say liaison with L&D due to VC's presentation, unable to assess his capacity due to minimal engagement and concerns regarding his delayed responses and previous mental health issues. And then you go on to say what Louisa Hagan said about Mental Health Act assessment. There's another entry in respect of this that I'll take you to before I ask you some questions about it. And that's at NHFT 0000168, page 272. It's the entry at the bottom. And it's an entry from the perspective of liaison and diversion. When you visit them, they refer to you coming to ask for some advice in respect of the samples. Based on history and current presentation, you believe he's mentally unwell, not fit for interview. There's reference to the Mental Health Act assessment process, going to gatekeeping in the crisis team. Just in respect of this entry, by your recollection, is this accurate?
Yes. I would say that we were probably there more to seek advice in terms of, it was more information gathering, in terms of we hadn't determined that we were going to request a Mental Health Act assessment. We wanted to see that if we were to re-engage with him and he gave us more engagement and we could assess him correctly and more thoroughly, should we want to request a Mental Health Act assessment, would that be accepted?
So this was one of those circumstances you were talking about at the beginning,
Yes.
where you go to liaison and diversion to consult with them
Yes.
about whether or not to have a Mental Health Act assessment.
Yes, that's correct.
There's a reference to you being unclear about the Mental Health Act assessment due to the nature of the alleged offence. What was it about the nature of the offence that led you to being unsure? What were you uncertain about?
In my experience as a healthcare professional in custody, anybody that has committed an indictable offence, in my experience, if they have been deemed to be mentally unwell, have not had a Mental Health Act assessment in custody.
There's then reference to a Teams call back from Louisa where she delivers some advice. Advise the HCP to follow their escalation process and that the trust stance is he will not be admitted to a psychiatric unit due to the nature of the offence, therefore no need for HCP to call to request this. What did you understand you were being told?
That should we, once we reassess VC, should we find that he was mentally unwell, not to request a Mental Health Act assessment.
Did you see this as leaving any room for a mental health act assessment?
No.
What about, instead of going through the L&D process, going to the crisis team and the gatekeeper there?
I took Louisa, who's the service manager, I took her advice at that point. She had stated it was the trust stance.
And you saw that as a categorical, there's no room for a mental health act assessment here?
Yes.
What did you understand the reference to HCP escalation process to be?
Our escalation process in terms of mental health is to go through the mental health services. So if they decline at that point, then that's as far as we can escalate in terms of mental health. We could also escalate to the police, and in some circumstances we could escalate to our medical director, who would then escalate it across.
It would seem from what you're saying now that reference to, in these circumstances, HCP to follow their escalation process is a bit nonsensical, because that's what you've already done by going to L&D.
That's correct. I escalated it to the mental health experts, yes.
Did you question this at the time with Louisa?
No, I did not.
Now, the real issue here is that during VC's time in custody, he wasn't subject to a mental health act assessment or a forensic psychiatric assessment or other fulsome psychiatric assessment. It appears there was a gap. Why do you think that happened?
I think that we assessed him and we escalated it appropriately, and we were told that it wouldn't happen. So I believe that's why it didn't happen.
And looking back, do you think it should have happened?
On my assessment with VC, the second time I went to see him, he wasn't exhibiting any obvious signs of mental illness.
Should we go to that assessment and bring it up?
Yes.
It's at NGPF 0002379, again, and page 2. And we're now on the second half of the page, the bottom half. Is this the assessment you're talking about?
Yes, that's correct.
And what was your impression from that assessment?
My impression from that assessment was that VC displayed capacity to decline toxicology and body mapping and to attend an interview with an appropriate adult.
Right, so let's go through some of your observations. So you're told he's just seen his solicitor in a face-to-face consultation.
That's correct.
So you go back to him.
Yes.
You ask VC how he's feeling. He replies, whatever. He says he's not got any pain. You specifically ask about voices or hallucinations. Was that based upon the previous history you had?
Yes, that's correct. And knowing that his relapse symptoms included auditory and visual hallucinations.
He responds, I don't want to discuss that with you. He answers maybe later in respect of whether he wants to engage with L&D. When asked about body mapping and toxicology bloods, he responds, not yet. You ask why. He says, I just want some time to process it all. And again, he says, yeah, maybe later. And then towards the bottom of the page, you say that he's not responding to any unseen or unheard stimuli throughout assessment. He's responding clearly and coherently to direct questions, although slightly delayed. And finally, over the page, onto page 3, we see fit to be interviewed with appropriate adult. In terms of assessing him as fit to be interviewed but with an appropriate adult, why did you come to that decision?
Under PACE, anybody with a vulnerability would require an appropriate adult. So knowing his history of mental health, that's why I suggested an appropriate adult.
Was that based purely on the history?
Yes, and his presentation at the time.
There's no reference in this entry explicitly about consent or an assessment of consent for taking intimate samples, is there?
No.
Did you assess that at this stage?
Consent for his toxicology and body mapping?
Yes.
I asked him if he wanted to undertake those procedures, and I believe he said, no, not yet.
Your previous concern was about his capacity to
Yes.
consent, wasn't it? Did you assess that at this stage?
Yes, and I felt he had capacity at that point during that assessment.
But there's no mention of that issue in this part of the entry, is there?
That he has or hasn't got capacity, I'm sorry.
Well, there's no treatment of it. There's no discussion of it in this part of the entry about capacity, is there?
Can you go back a page so I can...
Yes. On to page 2, I think.
I don't see it in this entry, but I potentially may have written it on my niche records.
If we go to the next page, we see that the final line at the top box is advised night HCP to reassess VC for body mapping and bloods.
Yes.
Does that not suggest that you were looking towards the night HCP to do that capacity assessment?
No, not the capacity assessment. During my interaction with VC, I asked him about toxicology, and he had replied maybe later. So hence why I then wrote for the HCP on the night time to ask again.
And is that what you meant by reassess?
Yes, and capacity would have been reassessed at any interaction with all the healthcare professionals.
And finally, if we could just turn then to the niche record in respect of this entry, and it's CPSE 605. Page 18. And it's the bottom of this page, it's the bottom entry. We can see this is an entry made by you, isn't it?
That's correct.
Examination start time 4 o'clock, examination end time 5:53. So that seemed to encompass all of what we were looking at in the previous entry. And you give details engaging with HCP deemed fit to be interviewed. DP stated may do body mapping and samples later. Again, there doesn't seem to be any explicit record of assessment of capacity to consent, does there?
No.
And for good measure, if we could go to the next page where the entry continues. It's not there either, is it?
No.
So there's no record, is there, of capacity to consent for intimate samples being assessed at this stage?
No, there isn't. However, if VC did not have capacity, I would have documented that he did not have capacity. And we are to assume capacity unless proven otherwise.
But you'd previously had concerns and explicitly noted those concerns about capacity, hadn't you?
Yes.
Chair, I have no further questions.
Thank you.
Maybe some.
Mr. Maloney, no. Yes, thank you, Mr. Beer.
Good morning, Mr. Draper. I'll ask questions on behalf of the Trust.
Good morning.
Can we look, please, at NHFT 40168 at page 272. And it's the bottom entry. Again, it's the one we've been looking at. And in the first paragraph, sorry to orientate you, this is a record on the Rio system of the series of calls at about 5:30
Yes.
on the 13th. And you see in the first paragraph, 4 lines up, it says Rosie advised that usually in these circumstances she would request a Mental Health Act assessment by calling the crisis gatekeeping and the AMP, but she was unclear whether to do this in these circumstances due to the nature of the alleged offence. Is that accurate? Is that what you said?
Yes, I did say that, yes.
And that would be the case, would it, even if it was between 8 a.m. and 8 p.m.?
So, as I have previously stated, dependent on workload, if mental health team, I have done this in the past in my experience, if L&D have a large workload, we can help them.
Even if it was between 8 a.m.?
Yes, I have done, yeah.
Thank you. The second paragraph, where it's recorded that there was a Teams call back from Louisa who advised that the healthcare professional should follow their escalation process and that the Trust stance is that he won't be admitted to a psychiatric unit due to the nature of the offence. And then that was communicated to you.
Yes.
Is that accurate?
I don't recall being told to follow an escalation process, off from my recollection.
So just stopping there, when you said earlier to the previous barrister that asked you questions that this entry was accurate, are you saying that this bit now isn't accurate?
I'm not saying that it's not accurate. I'm saying that I don't specifically recall being told at that time to follow escalation process.
If you had been told to follow your escalation process, would you have taken that as a reference to Mighty speaking to somebody such as you, speaking to someone else within Mighty, more senior, to arrange for a mental health assessment? The Mental Health Act assessment.
I would have taken that as I'd escalated it to L&D. I was told by Louisa Hagan, who was the service manager, that the Trust stance is that we would not be admitting him to a unit, a psychiatric unit, and there was no need for a HCP to request a Mental Health Act assessment. So I would not have escalated that further unless I had reassessed VC and determined that he needed a Mental Health Act assessment.
Even though on this hypothesis, this is L&D telling you to follow your own escalation process, your answer to that is that you would have gone back to L&D, even though they're telling you to follow your own escalation process.
I think you've misinterpreted what I said. If I'd have gone back and reassessed him and determined that he was in need of a Mental Health Act assessment at that point, then I would have followed an escalation process.
It could have been
that could have been L&D. If it was out of their hours, I would have called the gatekeeper myself.
And are you saying that simply didn't arise because on assessment there wasn't a need for
that's correct.
That kind of, in inverted commas, escalation?
That's correct.
Thank you. Thank you very much, Jim.
Yes, thank you. Just one question in relation to the, I suppose, interaction between L&D and your own escalation process. I think what you've effectively said is that that's actually quite flexible depending on not only whether it's within working hours, but also capacity, workload capacity.
Yes, correct.
And that in essence, you try and help each other as to who has the availability to carry out if it's necessary.
Yes, that's correct.
But on this occasion, if you'd found it necessary on assessing him, not a Mental Health Act assessment, to have a Mental Health Act assessment, you would have gone back where? Where would you have gone at this stage?
At that point, I probably would have contacted the crisis team and escalated it through to our medical director as well.
And was that because effectively you'd been told that the Trust's stance was that he
Yes.
wouldn't be admitted?
Yes, that's correct.
Thank you. Yes, thank you very much.
Thank you.
We'll take a 5-minute break now, thank you. Yes.
Chair, may I call, please, former Detective Superintendent Lee Sanders?
Please repeat after me.
I do solemnly,
sincerely and truly,
declare and affirm
that the evidence I shall give
shall be the truth, the whole truth, and nothing but the truth.
Please be seated.
Thank you.
Mr Sanders, I think you've prepared 2 statements for the inquiry. The first dated the 12th of January 2026, the second the 24th of February 2026. Can you confirm that the contents are true and accurate as far as you're concerned?
That is correct, ma'am.
And in terms of the events that the inquiry is examining, at that time you were Detective Superintendent, is that right?
That is correct.
And you're now retired.
That is correct too.
Can I ask you, please, firstly, to go to paragraph 7 of that first witness statement, WITNO 359001, page 3.
Yes.
And you set out at paragraph 7 on page 3, I'm sure it will come up in a moment, that at the time of the attacks you were head of homicide and MC investigations with EMSOU, EMSOU. Can you tell us what that entails? Is it a liaison collaborative role?
Yes, so EMSOU is the name given to the 5-force collaboration of the East Midlands. The 5 forces being Nottinghamshire, Derbyshire, Lincolnshire, Leicestershire and Northamptonshire. Effectively, it's a regional and organised crime unit that's brought together to bring about the capabilities of those 5 forces as part of the ROCU. So the unique thing about EMSOU is that it's the only ROCU within the UK within which major crime is a part of. So I was the head of the major crime unit within the ROCU, and I would coexist with other disciplines within the ROCU, including serious and organised crime, digital and technical capabilities, forensic science services, the sensitive intelligence units, and counter-terrorism, and obviously other partners that are associated with those.
So would Nottinghamshire Police with Leicestershire Police have a liaison points of contact?
Yes, so in terms of major crime, although we sit within the ROCU, the structure of major crime was I would have 15 senior investigating officers working for me across the 5 forces, and there would be a major incident room in each one of those forces, headed up by a detective chief inspector reporting to me, and then across the 5 hubs in total, there would be 15 senior investigating officers, and we'd be responsible for all the homicides and serious crime across the entire East Midlands.
And presumably it's not just serious crime where effective liaison can take place. If there's the relationship building and the respective roles in both forces, that should work across levels and tiers of offences and crime, shouldn't it?
Not necessarily. In terms of effective working, we are talking about the high-end capability. So in terms of homicide and major crime, most certainly. In terms of the other high-end capabilities, so if we're talking about serious and organised crime, yes. But if you're talking about the day-to-day management of the constabulary, that's very much part of the day business of the chief officer team and the structure within the force.
And what about picking up offenders who cross those territories which are relatively close to each other? That's something you'd expect there to be liaison between forces about.
Again, if it relates to its area of business, because obviously there would be a tasking process that covers the regional collaboration, because the whole idea of the collaboration itself is to tackle, as the statement says, the most serious crimes that there is. So clearly, there would be a tasking process to look at the most serious crimes. If it comes within the umbrella, then yes.
Just dealing with area of business, in terms of police forces, what's your area of business? Where the offender is residing or where the crime has occurred? Or both?
It can be both, but predominantly the responsibility would be for the commissioning of the index offence, the serious offence, within the East Midlands.
So the most important offence within the East Midlands would be the force that tracked the offender, wherever they were living in the East Midlands?
Yeah, so for example, if there was a homicide in Northamptonshire and the offence were traced to Lincolnshire, that would still be part of my remit.
Can I ask, please, that we put on the screen LEPF 0000660, page 1. You may or may not have seen this, Mr. Sanders, in the plethora of documentation you receive, but just so you're aware, this is an audit rebuild by an analyst in respect of information available to Leicestershire officers at the time VC committed the offences at Avato.
Okay, I'm aware of the Avato offence.
Yes, you are. You've investigated them. Nothing will surprise you, perhaps the format. Let's just see the document, please. LEPF 0000660, page 1. There we are. Is it possible to enlarge that, please? So Leicestershire officers were taken to this document, Mr. Sanders, when they knew of VC committing the offence at Avato. And we see that what appears at the top, don't worry about precisely how it appears, because obviously this has been recreated after the event, but clearly court warrant in relation to the offence in Nottingham against a police officer. So first instance warrant, not back for bail, issued on the 22nd of September by Nottingham magistrates for the arrest of VC. So Leicestershire have evidence of an offence in Leicestershire there and then, but importantly, the index offence is the one in Nottingham, isn't it, and referring to an arrest being outstanding.
Yes, so I haven't seen this document, but
Sure.
I can accept what you're saying. Yes, I can see the highlighted section at the top that says court warrants.
So if that's an offence, and that's a serious offence against an officer, isn't it, and not attending court, not back for bail.
So there is a fail to appear warrant in existence, yes.
And the offence itself, arrest of VC for assault by beating emergency worker. I think it's Operation Hampshire, the policy. Is it Hampshire, something like that?
It's Operation Hampshire is the sort of welfare policy that goes with regards to the assaults on police officers.
But very importantly, recognises they need to be taken seriously and they're a matter of public concern when emergency workers are assaulted.
I think all crime needs to be taken seriously, but I understand the ethos of what you're saying, absolutely.
Yeah. So you have an officer, one of Nottingham's officers, assaulted, and the inquiry, of course, has seen, I don't know if you ever saw, did you ever see the video of that assault?
I haven't seen the video of the assault, but obviously it was identified when we did our research into the homicide around VC.
But at this time, I'm not saying you had access to it at this time, that is a serious entry that demands action, doesn't it? That he is wanted for that offence and there's a warrant not back for bail. Do you agree?
Yes, there is a warrant for that individual outstanding, yes.
And this isn't the benefit of hindsight. This should have been dealt with as soon as it was viewed and contact made with Nottingham.
Yes.
And what would Nottingham have done if they were alerted to the fact that this person had committed another crime in Leicester and was wanted for this and by a court and not back for bail? Let's assume liaison officers are notified in Nottinghamshire. What should they have done at that point?
Well, obviously I deal with high-end crime, so in terms of the process...
Just
within
pausing there,
Nottinghamshire,
I know you deal with high-end, but this is a significant event, isn't it? You're not
it's a...
minimising that.
It's a warrant. So what should happen is, once identified, it should be either action by the officers who've seen it or referred to the relevant force locality for them to progress.
When you say, first of all, actioned, should have been actioned, so one or other, if it was actioned, what does that mean? Picking him up?
Well, action will be, I would suggest, either, if it's in your locality, executing the warrant.
And how would a Leicestershire force do that? Would they be able to do that?
I don't actually work for the Leicestershire Police Force, but I would suggest if there's a warrant in existence, as with all warrants, if it's within Leicestershire, then I don't understand why it couldn't be actioned in terms of arrest, or it could have been referred to the relevant force. I suppose it depends on the context of what the search and the question that are being asked, I suppose.
And either way, whether it was Leicestershire or Nottinghamshire, one of them should have arrested him at the point this was known.
Yes, I don't dispute that.
And we know that it was known, or should have been known, by the 24th of May 2023. So let's carry on with my questions. Assume that Nottinghamshire had been told about this and had picked him up. What should have happened next? Where would he have appeared?
If VC had been arrested on the failed to appear warrant,
Yeah, at the end of May, yeah.
I would suggest that he would have had the warrant that was not back for bail executed and then be
Yes.
put before the next available court.
Yes, so he'd have had a duty solicitor and appear at the magistrate's court. Yes, that should
Correct.
have happened.
Yes.
And then it would have been a judicial decision about what happened next, whether he had assessment, whether he was detained in custody, or what happened next.
Yes.
And if, as appears to be the case in what happened only a short time thereafter, if medical assessments were required and the like, he was likely not to have been at large, wasn't he, at this point?
Well, I can't answer that because it depends on what assessment would have been made and what that assessment would have come to the conclusion for.
Well, you knew, we'll turn to the investigations anyway, but you knew the working diagnosis on the 13th of June was he was a paranoid schizophrenic. So should he have been in front of a magistrate's court at the end of May, have you any reason to think it would have been a different working diagnosis quite rapidly as events unfolded?
Again, I suppose the role of the police service would be to put him before the court.
Yes.
And then obviously it's the wider criminal justice system that kicks in and then those assessments will be made.
Yes. And of course, I'm not asking you to be the judge of that. It's a matter for the chair, what should have happened or would have happened or may have happened. But as I've said, given what happened in June, this was so close to those events. And the working diagnosis was paranoid schizophrenia, wasn't it?
By the time that the offence that I investigated, yes.
So do you agree that was a significant moment in the chronology of these events? A significant moment where it should have been avoided that he was at large in June?
I think it's significant that the warrant wasn't executed, and it's significant that he wasn't put into the criminal justice system. But as I say, I can't really provide an outcome for what the criminal justice system would have done with him in that process.
Well, we know what happened in the criminal justice system through the process, don't we? But you're saying you don't want to, make any inferences from that?
No. In terms of my investigation, quite clearly the diagnosis from the treating psychiatrist was paranoid schizophrenia.
Just going back to information sharing, if I may.
Yes, of course.
The university in 2015 had a sharing arrangement, information arrangement with the police. Was that anything you came across or understood?
No.
And we know that in relation to this assault on PC Pritchard in September 2021, they weren't told about that or didn't know about that till January 2022. They didn't know that a student in their community had committed that offence. Can you think of any reason why the police wouldn't notify the university about that matter?
I suppose the answer is no. I can't see why information sharing, if it was relevant to the university, wasn't shared.
Well, just pausing. Do you see it relevant? He's attacked a police officer. He's being detained. Astonishingly, the university doesn't know either of those things.
If he's a student at the university and he lives on the university, then I would suggest that they would be an interested party, so they should be informed.
Does it matter if he lives at the university? He's in and amongst the students, isn't he? If he's studying at the university, wherever he lives.
I suppose it doesn't necessarily matter where he lives, but if he's a student at the university, then obviously there's a requirement to look at the holistic treatment of that individual for that person's well-being. So yes, to that extent, sharing information for that person's well-being and also for the university to make its own assessment is not an unreasonable thing to say.
And his well-being is one factor. Another factor, of course, is the risk he may pose to others. Would the police be interested in sharing information about the risk someone might pose to those around them in the university?
Yes. And I suppose it depends on the information available at that time and the risk that was probably assessed in relation to that individual and how then that manifests in how it should be shared.
Well, the police, of course, might not know the mental health assessments and the details of those. That's for medical teams. But you would be expected to know risks to the public and call-outs in relation to somebody and their impact on people in the public. That is what the police do, isn't it?
Yes.
You detect crime and you prevent crime. So as part of crime prevention, should someone have let the university know about that?
It's a tricky question to actually answer because I suppose what the suggestion, if you take that logic forward, would be that any interaction that the police service would have with a student, would we share that information with the university as a matter of course? And the answer is, I don't know.
To be fair to you, Mr Sanders, there's an updating agreement in 2024 and the university, I think, get more information than they would under an agreement in 2015. But in terms of the culture of the police, and you've had extensive experience within the police, is the culture to share that kind of information in the interests of public safety, or would you be concerned whether that was contrary to the interests of the suspect or patient or anyone from your perspective that you're sharing the information about?
I think information sharing agreements are a complex thing that sometimes people get hung up about. In terms of communicating, I think that is an issue that exists across all organisations. Should information be shared? Yes. But again, an assessment, I think, has to be made in terms of it has to be done legally. There has to be an agreement in place. And I suppose we have to consider what is it that we're sharing and for what purpose.
And do you think there's enough confidence within the police around that? And for example, if a psychiatrist phoned up, you leading a homicide investigation or others and saying, what can you tell me about this individual? We're concerned, we're not sure if we need to know more about what's happened or what they've done. Would you feel able to share information with a psychiatrist who phoned you about a patient?
I'm a bit confused by the question.
Police information. If you had information about somebody's previous encounters with the police, convictions are a bit easier, aren't they? Because they're a matter of public record. But previous encounters.
If a psychiatrist was to contact me...
Yeah, and say, what information do you have on this person? I've assessed them. Not sure what they've just told me is right about a particular issue. Would you give them the details from the police perspective or not?
Well, if it's an instructing psychiatrist, then surely there would be information in place, an information agreement in place in order for that to occur.
Do you mean a treating psychiatrist? I'm talking about a treating psychiatrist, not something for the court process. If somebody working in a hospital wants to get some more information from the police about the patient they have seen to understand what risk they might pose, would you be prepared to hand that over if somebody phoned you?
That's not an unreasonable question. I'd like to be able to think for the greater good the answer would be yes. If I was being honest, I would probably have a telephone conversation with legal services to find out about the relevancy and the availability and what the legal position would be surrounding that. But in principle, yes, but I think we'd need to ensure that that was done correctly.
We know in relation to the Brook Court incidents, and you know what I'm speaking about.
What, sorry?
The Brook Court incidents, the 3 that VC was involved in.
Yes.
Back in May 2020 and then July 2020. We know that the university found out about the one where the woman jumped out of the window requiring surgery to her back in June 2020. And they never found out about the first incident when he went in. Again, that level of information sharing or not sharing information, do you think that's an important issue moving forwards to understand the risk that people may pose in their communities?
Yes.
I'm going to move now to your decision log and your involvement in this case. And it's a substantial involvement, isn't it, as the senior investigating officer? Could you tell us what that role means?
Yes. So, as the senior investigating officer, I was the lead investigator of a team responsible for the investigations into the Nottingham attacks. So that would mean I would be tactically and strategically responsible for setting investigation plans. Obviously, we would look at investigation strategies in accordance with the Major Crime Investigation Manual. We would look at resourcing. I made mention previously to major incident rooms. So we would, or I would, set up a major incident room and ensure that the infrastructure was in place in terms of administrative support through homes, for example.
What's homes?
So homes is the Home Office large major inquiry system, effectively a big computer system that enables us to administer the investigation, to gather and record all the decisions that are made within the inquiry, and it basically acts as a repository for the information that then comes into the room. There's a system in place through MERSAP where the information is assessed, and then inquiries are generated or actions, and they are passed on to detectives.
Do you think just dealing with systems generally in the police, the tech systems, they're sufficiently understood by those using them? What can be accessed, how you can access it, what you can do with them?
I think that a lot of police organisations are no different to other big organisations in as much that often, so talking from my perspective as a major crime SIO, the homes database will not be accessible to everybody. It will be accessible only to those who are actually working on the major crime unit. And even within the major crime unit, you may have access to the homes account. For operational security, you may not have access to all the homicides that are listed within that database. So you'll only be listed to the ones that are relevant to your investigation. So
No, please.
I was going to say, so the simple answer to your question is, there are different systems that different people operate.
And what about the niche system? Is that widely used across forces in your experience?
So the niche system tends to be I would say, the daily administrative workhorse for the organisation, if I can put it that way, where intelligence, crimes, custody records, that's where the force would probably do its day business, and that's how they would investigate and list their crimes. Obviously, the complexity, as can be seen from from the investigation that we have with the Nottingham attacks, that database simply would not be able to cope with the infrastructure and the administrative support required to support an investigation of that type. That's why the home system exists for major inquiries.
Let's go then, please, to NGPF 0008791 and begin with your decision 1. So I'm going to refer to decision numbers so people can follow through the document because it's got one unique reference number.
Okay, yes.
And you see here, you say, I, Detective Superintendent Sanders, will perform the role of SIO. And you set out the briefing that you have had. And this is at 6 a.m. on the 13th of June.
Yes.
The inquiry's heard evidence from officers, some senior officers too, or certainly inspector ranks, and about what their first impressions were of the first attacks and what they thought they might represent. Did you have any briefing or handover or discussion with people about what they thought these series of attacks were, either separately or in combination?
So the MSU major crime structure sits above the 5 forces, and there's always a 24/7 on-call function. So I had a call before 6 o'clock. That's why there are perhaps references later on that we'll come across to other decisions made. I was already on the road to Derbyshire in relation to a briefing for a separate incident, and the initial call I got from the on-call homicide for major crime was that there had been a stabbing and one had died and one was seriously injured. That later on, as I continued driving towards Derbyshire, as they were going to deploy to that, changed to there's a van now driving people or driving around the city centre and knocking people over. And then that then got updated to there's been another body found. So quite clearly I turned round and drove back to Nottinghamshire. I then obviously have had a call from ACC Griffin and informed me of the briefing that I took there as described in Policy 1, really.
And you say the incident has been declared as both a critical and major incident.
Yes.
Why did you think, and when did you think it had been declared as a critical and major incident?
So, from memory, Mr. Griffin had, I believe, declared it as critical and major. I think anybody with a modicum of probably common sense would probably see with the complexity that was clearly unfolding, it was always going to be both a major and critical incident. So I would suggest probably in the call from Mr. Griffin. That said, I think it would be fair to say that with the circumstances being relayed, that inevitably I think it was always going to be called a critical and major incident.
So whatever route it arrived at that, as far as you were concerned, the number of casualties, the events that you'd been hearing over the radio, this was clearly a major and critical incident.
So I didn't hear them over the radio. There were calls onto my mobile. And so I wasn't getting live dynamic updates. I was getting calls into my mobile phone with updates as the events unfolded.
We see decision 5, please.
Yes.
You have categorised the investigation as a category A. I've no idea for the motive for this attack or at this stage can say with any degree of certainty they are linked or how many offenders are involved. Relationship between offender and victims is yet unknown. Added complexities of multiple scenes and victims. This was at 8 a.m, wasn't it, on the 13th of June? And the custody log, we were looking at it yesterday, and VC's arrival into the custody suite at 6:10 a.m. How much communication were you having with those at the custody suite about his identification, for example, which was established quite early on?
None.
None. So did you know his name or the details that they had got for him?
No. So
7:30?
no. So my briefing commenced when I arrived at Radford Road Police Station at 8 o'clock.
So if we go to decision 6, here you say, at this moment in time, these acts appear to be attempts to cause really serious harm to people indiscriminately. These actions appear to be attempts to murder other individuals. So this is 8:30. So what update do you think you've had by then?
So when I've arrived at Radford Road Police Station, I had a briefing from Pam Dawson, who was the on-call detective inspector, and she provided me with the details that you see there that allowed that mature assessment at policy 6 to be made, which were clearly identity of individuals, both deceased and others who had been knocked over. And in addition to that, whilst it may not be reflected in that policy log, quite clearly there would have been a bit more meat on the bones from her briefing.
Detective Inspector Dowson's evidence to the inquiry was that she said on handover she urged you to ensure swift notification to the families of the victims.
Yes, yes, that's not an unreasonable thing to say.
Well, it's an essential thing to say, isn't it?
Yeah, no, what I'm saying is I can't remember her saying it, but it's not an unreasonable thing to say. And
She's not wrong about that, though. You're not suggesting she's wrong.
No, absolutely not. I'm not saying she's wrong. And that is a critical thing to consider, and I think I've made a policy entry in relation to that. So I think...
Can we just go to that policy? That might help you, having mentioned it. Major Crime Investigation Manual, version November 2021, NGPF 0008898. Page 1, and if we can go to page 28 of the document, it highlights on taking command the senior investigating officers should as a priority, and we see fourth from the bottom, ensure that the victim's family have been notified and allocate a family liaison officer.
Yes.
So that was firmly your responsibility, wasn't it?
Yes, and I take complete responsibility for the homicide, yes.
So that can come off the screen, and if we can go back to the decision log, decision 10, please. So it's NGPF 0008791. Decision 10 at 9:30 a.m. Actually 8:50, sorry, recorded DI Claire Gould has been appointed FLA and is to coordinate the appointment of FLOs with a task surrounding their deployment ASAP.
Can I go above that? I think I've made
Yes.
a policy decision before that, policy
Yes.
decision 6, if I may.
Yes. Been informed of the following deaths at this time. If we can enlarge 6, thank you. I think it's the other way.
So I received a briefing from Pam Dawson around
Just
about...
wait a moment, wait till
sorry.
it's in front of you and other people can see it too. So can it scroll higher up? It's decision 6 we're looking at. No, the other way, mature assessment victimology. Thank you. Thank you. Yes.
Can we... Sorry.
See, that's your decision 6. I've been informed of the following
Yes.
deaths.
So
That's at 8:30.
Yeah, apologies. So I received a briefing at 8:15, and so in the 15 minutes of that briefing, you can see that I've included in my rationale. Out of this assessment, a number of clear lines of inquiry have emerged as fast track, namely around victim identification and flow liaison. So within that 15-minute period, absolutely, it's a fast track action that needs to be progressed.
Well, who's progressing it? When you see that decision 6, you know who the victims are. Isn't that your first port of call? Who's phoning them? That's a call that
Yes.
needs to be made then, doesn't it? As soon as you know, they need to know.
Yes. So, first of all, D.I. Gibson, who had control of the actions around scene 1, I've asked her to start to make progression around that. Obviously, there's issues required around the validation. So, one of the questions for the golden DI was, how do we know who they are? Because obviously, I had not had a chance to read any of the detail.
Well, somebody else had. We know that there was
Yeah.
phone identification on them. Whoever gave you that information, immediate question, how do you know? We've got all the
No.
identification documents.
Yeah, I don't dispute that.
Yeah.
From my perspective, I've got some names for the work and hypothesis as to who I think the victims are. But equally, whoever's going to have the requirement to identify next of kin for the notifications, they still, for me, need to validate that information and then figure out who the next of kin for them are, so we know who it is that we're attending and speaking to in order to do the message.
So who did you contact to do that as soon as you got those deaths?
D.I. Gibson.
So you asked them to go and what? They weren't at the scene, were they? What information was
No, so
beyond?
D.I. Gibson was in the briefing with myself and Pam Dowson. And I've tasked D.I. Gibson to actually go and see what could be done in terms of validation and can we quickly identify next of kin.
If we look at decision 10, if we go back to that, you record here, calls are now started to be received into the control room from many people concerned. There is considerable media interest, and with the advent of social media and modern communication methods, it will be a matter of time before families here find out from media outlets.
Yes.
Just pausing there, never mind media outlets. Most, or lots of parents these days have Find My Phone in relation
Absolutely.
to adult children and friends. There are many ways of finding things out, aren't there? So the media and what they have to say is but one part of it.
Yeah,
How
absolutely, yes.
did you ensure, as the police, that you're up to date with that kind of communication?
So
And knowing that people are going to find out very
yeah,
quickly.
it's a tricky one. In
Is
as
it?
much, well, I think it is. I can't control, for example. So I've got it from my daughter. So I've got to Find My Phone app for my daughter, so I know my daughter's whereabouts. It was obvious that with large sections of the city in lockdown, there was going to be considerable media interest. One of the first things that I did in relation to trying to deal with that was, as well as setting up the major incident room, also have to set up the casualty bureau to deal with the calls coming in. But equally, we were still trying at that stage to try, it would appear, because policy entry number 10 is clear, by that stage, they still had managed to identify next of kin for the individuals.
That wasn't going to be difficult given the details you had about the victims, certainly the first two who had driving licences with them, were they? That's just a formality, following that through for the police.
Well, so a couple of things in relation to that, if I may. Obviously, there was a lot happening at that time for the operational officers to contend with. They're trying their best endeavours to try and identify the individuals. By the time that the briefing that I'd received by 8:30 had taken place, it's fair to say that we're already 4.5 hours maybe behind the curve. So we're still trying to catch up.
What was the reason for that when officers were at that scene? well before the City of Nottingham had woken up and had access to that material. We know there were a number of officers at the scene of the first attacks. Those things could have been happening in parallel with attendance at that scene, can't they? I mean, isn't this back to basics, finding out who these people are and notifying their next of kin? I understand, and we're going to see lots of references to you talking about the impact of the media and the scale of interest, but the basics of informing next of kin, following the suspect, tracking things, these are the essentials, aren't they, for the police?
Yes, I accept that. They are essentials. But I think you have to look at things in the context of the operational men and women on the ground and the complexity and the unfolding chaos that was happening around them in terms of the volume of scenes, in terms of the volume of victims, in terms of the fact that Plato had been called. So all these things need addressing. In terms of the identification, it would appear to me that quite rightly, in my view, that when the scenes were actually safeguarded to secure and preserve evidence because we were still trying to establish what had happened, it seems to me the right call that the scene is put on so that we can secure and preserve evidence, which probably means that perhaps some of the scene material was perhaps left in situ. That's not an excuse. I'm just trying to...
It's not, is it? If you talk about identifying information of victims, it's clearly not. There can't be an excuse for that, can there?
No, I'm not trying to make an excuse. I'm working on the proviso. So what I'm trying to explain is, I'm working on the proviso that the identity that I've been given is the actual identity of the victims. That's what I'm working towards. I suppose what I'm trying to say is that we are still, despite that, we have to get it right, because in relation to Elaine Coates, we didn't get it right. So we still need, or Elaine Newton, sorry, we still need to validate who they are. We need to do the work around them. We need to identify next of kin in order to make an informed decision then as to whether or not local police officers go around or officers from the inquiry go around.
You referred earlier to the chaos around them. That's the officers with everything that was going on. In major and critical incidents, there's a real need, isn't there, for good command and leadership at the top.
Yes.
To avoid a sense of people feeling overwhelmed in the organisation or people in your team feeling overwhelmed. It's the responsibility of those at the top to say, we've got this.
Yes.
We know what we're doing. You do this, you do this, we're doing this collectively.
I think the responsibility is to try and bring calm to the chaos that exists so people can try and operate and provide some clear thought and rational thought process.
And effectiveness, bring effectiveness to all of the activities of the individuals working at the time. Effectiveness as a group.
Yes.
Do you think that was achieved? I don't know if you followed the evidence, or if you looked at what had been done before your commencement as SIO, but do you think it was effective responding to the attacks and the way searches and the like were conducted?
So I haven't been following the evidence, so it's probably unfair for me to try and speculate as to what might have happened. From an investigative point of view, because clearly I'm the SIO for the homicide unit, I would suggest, yes, we did bring direction, we did bring control, we did bring order to the investigation.
And we know at decision 14, you were going to assist in getting, and 15, I think, getting technical analyses. And you, I think, put together through CCTV evaluation the timeline, didn't you? You got all the details about where VC was when he arrived, and you followed that through as part of the investigation.
Yes, obviously it sounds easy in the way that's been explained, but yes, we did, but it took some time, absolutely.
I'm not suggesting that was easy, but you needed to trace and follow him with the benefit of time and access to all systems. But I'd just like you to have a look at a couple of images, if I may. And the first is NGPF 0010192, page 41. This is one of the stills. I'm going to just show you a couple of the stills from the timeline, because one of the issues the inquiry is being hearing evidence about is how visible he would have been on searches, VC, and how recognisable from the descriptions that had been received at an early stage. Okay. So if we just have a look at material that your investigation uncovered, and if we could perhaps expand on the top left picture. So this is an image at 4:38 to 4:41 of VC captured on CCTV walking along Gregory Boulevard towards Mansfield Road.
Yes.
I'm not sure if this is council footage, this camera, but we can see there on his own, all dressed in black, fitting the description, and it's light, isn't it? It's not. It's a light morning where searching, you would see that he fitted the description.
The description of
they'd been
what,
given out of the suspect who'd walked off from the first attacks.
From that image, obviously I have, as does the inquiry team, the benefit of looking at hundreds and hundreds of hours of threading things together.
Understood.
So we can quite, from our perspective, we can say that. If I was to say a person looked at just that still, I would probably describe that, if I was being honest, looking at that as pretty nondescript. It's a bit of a dark figure on the right-hand side.
If you'd had a description that a dangerous man had left with a knife, having killed 2 people, and they were all dressed in black, the first description suggested he was fat, but that was remedied quickly. I gave his height, black male, dressed in black, with a rucksack. If you had that, and that's what you were looking for, are you saying that that wouldn't, if you had seen that, driven past that, you'd think that image or that this person is the person we may be looking for?
It's tricky because I know all the work that's got into it and the work that leads to that image. So I'm trying to answer it based on just that still.
Well, obviously, you wouldn't be looking at an image if you were on the road. You'd see the person, so it'd be even more clear than that, wouldn't it? I'm just saying that it was light and he is visible and fits the description and is seen walking there. What I'm not clear about are you. Did anyone look at the council footage?
Yes.
At the time? So
at
this time in the morning, were people looking at the council footage?
I can't tell you whether, do you mean from a reactive perspective to try to find him?
Yes.
I can't tell you that because we provide a reactive investigation to the homicide. So we would have obviously gone and collected it, and we would then the sift, the seize, and the trawl, and then we would have gone through all of the footage, and that would have included liaising with the council teams and securing not just private CCTV, but the council CCTV too.
The evidence we've heard thus far is that the council teams would have had access to that, but there was no officer who went down to, I think it's Woodlands Road. Where
Woodlands, yes.
Yeah, Woodlands. In your experience, do officers go there where there's urgency and you're looking for something or someone, or you want to see it from a policing perspective straight at the time?
So we would have actioned that pretty quickly to go and liaise with Woodlands, yes.
Would you? When you say actioned, what would you do?
So we would, quite clearly, CCTV strategy would have been identified as a key line of inquiry. Yeah. We would have identified officers to trawl CCTV. And then, obviously, we would have gone on the sift and seizure. And then one of those key lines of inquiries would have been to link in with the Woodlands because it's the council CCTV.
And we see the same number, page 48, another image. 13th of June, 5:12. This is the map showing the route taken by VC from Sealyhurst House towards Magdala Road. You see the bottom left?
Yes.
You see there as well. It's really light then.
Yes, it's light. Yes.
Again, as someone, no doubt, from the police, I know you're no longer there, Mr. Sanders, will be able to confirm for us whether these were council cameras that took these images as opposed to private cameras. You clearly gained a lot of footage from private cameras as well, cameras such as Sealyhurst House. But these look like they might be street cameras, don't they? But we can check that.
I think we probably need to check it because we will overlay private council with our own self-generated maps, but each one of those stills would be provenance to the source document that relates to it. So that's how we could provenance that quite easily.
Thank you. Well, we'll look forward to the confirmation one way or another of that. That can come down, please, and if we can go to NGPF, back to your decision log, 000871, decision 20. You say at decision 20, I'm yet to establish as anybody other than a single person responsible. Preliminary opinion only, and I retain an open mind. Assessment comes from CCTV and descriptions. Can we go back to your witness statement, please, at page 49? It'll come on the screen. To deal with the CCTV gaps. Might be easier for people to follow if we start at page 48, paragraph 117. So I'll give people a chance to read that, just scrolling carefully down if we can, please, Sarah. Give people a chance to see the routes that you've identified by now that VC took.
Starting which paragraph? Sorry, 100 and...
I'm going to go, it's 117, we've gone a bit further down now, but you know the
yes.
route. Just a little bit slower, Sarah, so people can read it, please. Then on to 122. 124, if we can highlight, I want to focus on 124, please, and 125. So this is the first period where CCTV, you can't find anything to capture his movements between effectively 1:37 and 2:19, so 42 minutes. You've done a really comprehensive job about getting cameras from anywhere and everywhere at this point, haven't you? You've got private cameras, you've got Nottingham cameras.
When you say this point...
Well, in your investigation, when you're writing
yes.
this statement, you have done all that you can.
So at the time that this statement's been written, absolutely, there's everything that we can do has been done, yes.
So doing the best you can, looking at that period, is it likely he was still walking around somewhere and you haven't captured him? Do you think he may have been in a house or a flat somewhere, or do you simply not know? Why do you think it is his movements are not detectable at all for those 42 minutes?
It's impossible to say. So we have not just looked at the CCTV, but we've overlaid it with, as you'd expect, other investigative strategies such as any financial work,
yes, all that.
Telephony, intelligence reports and such like. And the answer is we can't tell you. That's the simple answer. And we cannot find him on CCTV.
And as you say, there's no financial transactions, no attendance at any other place that you can. And you've looked at phones. We know the SIMs have changed. Indeed, your second statement clears up, thank you, issues arising from calls that appeared to have been made to his phone. He was swapping SIMs, and you've tracked and traced where that was happening and the impact on the calls.
Correct, ma'am.
So a comprehensive job on his phone analysis.
Correct.
And you also had all his zip files, and you had assistance, didn't you, from Nathan Shaw from counter-terrorism to look at what was on them, what they might represent, what was relevant, what wasn't, etc.
Correct.
So none of that assisted with this. And also, if we look at paragraph, sorry, I need the statement back for 127, paragraph 127, page 49. This is the second period where he disappears from view, and you identify at 3:30 hours he disappeared from view off Ilkeston Road near to the pathway providing access to Hopedale Close, a shrubbed green area containing a large tree adjacent to that pathway. Here, someone could remain easily undetected out of view if they wished.
Yes.
And you say at 128, in your view, with no further sighting of VC between 3:30 and 4, he remained in or close to that shrubbed area until his victims walked past, hidden from them to get the maximum effect of surprise. Is that right?
Yes.
Chair, I think that might be a good time for the morning.
Yes. We'll stop there. We'll start again at 25 to. Thank you. Thank you.
Can we go, please, to decision 24, NGPF 0008791? Decision 24 at 12:15 on the 13th. On the basis of the information available at this time, nothing uncovered that suggested this series of incidents is ideological based or relevant to counter-terrorism networks. Having reflected on the briefing and the dynamic actions that have already been undertaken, the following are my favoured hypotheses. Not an act of terrorism, rather violent acts of criminality by an individual or group of individuals. Since that time, of course, you have had the full analysis of telephones, and the inquiry's heard some of what was viewed, some of the images, and indeed we've done a summary, inquiry legal team summary. If I can ask that we go to it, please, at INQY 600001 and go to page 6 and 7. We see a number of documents, don't we, and you've assessed all of this yourselves within the files as well. What is looking at about mind control, lots of health stuff. There are some files detected as relevant to terrorism or shootings that have been observed, but there's a lot about health and mental health and mind control as well, isn't there?
Yes.
But we see on page 6, academic educational documents, we've listed them under those. A research paper titled Psychosis, A History of the Concept.
Yes.
Various documents are relating or potentially relating to mind control. And if we see at D, policy documents, including a copy of the Mental Health Act 1983, a copy of the General Data Protection Regulations, and other documents relating to police powers and regulations. Did you, in the plethora of information, it wasn't such that that might have leapt out at you at the time, but do you think that's interesting now when you look at it, that police powers have been reviewed and health acts, mental health act stuff?
Yes, because these are from the exhibit EAMC1, which is, I think, part of the zip files that were sent to his brother.
Yes.
So, yes, I think they are significant, and they were made available to individuals in the inquiry to review, yes.
Mm-hmm. And would that have been available? Was that picked up, as far as you're aware, by the prosecution at the time, and that there were documents relating to police powers and regulations that had been found to have been...
I can't remember now when it was picked up, obviously, because of the plethora, because the amount of material coming in was enormous. But quite clearly, it would have been reviewed. I just can't tell you when it was reviewed. Reviewed as unused or just as a part of the information? It would have been assessed to determine whether or not it progressed the investigation. I do know that that exhibit reference was passed to the psychiatrists. Over and above that, I can't really, at this moment in time, remember when it was assessed, if I'm being honest.
That can go down, thank you. We'll go back to your decision log, decision 24. So you at 12:15 are saying not an act of terrorism, violent acts of criminality by an individual or group. We know that Chief Constable Kate Maynell, briefing the press on 15:11 on the 15th of June, after VC had been charged, said we're still working alongside counter-terrorism policing and keeping an open mind on the motives. Did that fit with where you were at that point? You seem to have stated it's not an act of terrorism on everything you had at that point.
That was my developing hypothesis at the time. I was favouring more that it was looking more as if perhaps it was a criminal act or mental health, as I've put in the rationale also below. I can't account for the Chief Constable's hypothesis. My focus at this time was purely and squarely dealing with a triple homicide. So the other noise, if I can call it that, around media reporting was taking place, and I wasn't aware of it.
Did she contact you before making a briefing on it on the 15th of June about the status of the investigation and what conclusions you'd arrived at this point?
I can't remember.
Okay. We know, of course, Professor Blackwood was retained by the CPS on the 14th of June. Can you remember when you first had that conversation with the prosecution about a psychiatrist likely being needed by the prosecution in the circumstances of the case?
I'm not sure I was privy to any conversations regarding the retention of a psychiatrist. I suppose that's the domain of CPS. I certainly had conversations with the CPS from, I believe, the 14th onward. So they would have been obviously briefed in relation to the inquiry. And then obviously we would have been feeding information through to them. And obviously they would have had contact and information provided from the file officers, and they would have had the IMD that subsequently comes the DMD for them to make their decisions. But as to instruction of psychiatrists or retention or retainment, that's something for the CPS.
If we go to decision 30, please. You say here, early press release prior to SIO appointment to the media resulted in calls to the Casualty Bureau from families of the deceased regarding their loved ones.
Yes.
And what were the media releases that had been made earlier that you thought had complicated the situation?
It's not a case that it would have complicated the situation. It was a case that obviously the media release had gone out, and arguably there was a necessity for that because large parts of the city were in lockdown. From my perspective as the SIO, clearly that was going to necessitate a huge volume of material coming in to the major incident room or the Casualty Bureau. And so my focus was trying to provide a structure that could actually receive that information and process it.
And what was the nature of the release? Can you remember the earlier release? And did someone who was putting that out consult with you about it?
No, that release would have been undertaken probably within the force control room environment, and that would have happened well before my appointment or my arrival as the SIO.
Decision 35. This is about the vigil. And you speak about flows will be deployed to the University Vigil in order to support families in any way possible. A coordinated media release with families with coronial agreements surrounding approved methods of identification will be required. This can have a significant impact on the reputation of the constabulary and will need careful handling. Why do you say that? Why do you speak of the reputation at this point of the constabulary?
Which bit now? Sorry.
It's the end of decision 35. This can have a significant impact on the reputation. Yeah.
So it was obvious by this time that the media interest in the case was enormous. It made not just national but international news. Obviously, the city of Nottingham was in the spotlight. There was a vigil taking place. We needed to provide as much support as possible, and quite clearly, we needed to provide a significant input into that. Because obviously, Nottinghamshire was in the spotlight, and so therefore, the management of that did need careful consideration.
Did you feel the need to communicate to the media what you were doing, rather than just getting on with what you were doing?
In terms of the media strategy, if I'm being perfectly honest,
Please
I left that with gold. My focus was purely and squarely in trying to secure and preserve evidence in order to ultimately convict an individual for one of the most horrific murders that I've investigated.
Can we go, please, to decision 38? Indeed, you've referred to murders there, and if you look here, you say, I've liaised with CPS and senior lawyers Sam Shallow and Alan Murphy.
Yes.
CPS will ultimately be invited to consider evidence in relation to possible charges for ×3 murder and 3 attempt murder. When you were liaising with those lawyers, would you have used the term murder and attempt murder, as opposed to killings, for example?
Yes.
And was there a discussion between you at that stage about the paranoid schizophrenia diagnosis, which the police were aware of, we know from the custody records, yesterday by the afternoon of the 13th?
I'm not sure I was aware of issues regarding mental health. I can't say I was aware of a diagnosis of paranoid schizophrenia. Clearly, the CPS would have been privy to our briefings, and we would have shared our investigative strategies with them. Did I refer to them as killings, as murders? Yes, I did. Is it my belief that they were murders at that time? Yes, it was. And they were the terms that I used with CPS.
And why was that your belief at that time?
My belief was based on the investigations that we'd undertaken in relation to VC. That included a number of the investigative strategies that we deployed. So clearly we'd had good evidence from the CCTV, from the telephony. He'd made admissions, he'd made contacts. For me, there was elements of planning in relation to the killings. My view at that time was he didn't seem to be under duress. He appeared to be making rational choices. My impression was that he was acting of his own free will. As an operational police officer, my view at that time was that I believed he had murdered in cold blood 3 people.
Can you remember now roughly when it was the CPS first raised diminished responsibility? It's not a memory test and we're going to go through decision logs, but just as you described that, that was your view. Can you remember when something different was said to you or you were aware that diminished responsibility may be an issue? We see it later on the logs, but I just wonder from that first conversation if anything was said.
I think we've just seen it in the policy log. Was it 24? Where I've started to move away from the hypothesis it could be terrorism, more towards crime or potentially mental health. So that would have been, what, about 1140-ish? Clearly, the intelligence work that had been undertaken by sensitive networks, if I can put it that way, whilst they'd identified there were no convictions criminally or for terrorism, it was becoming apparent at that stage that despite the absence of convictions, that there was a history of violence, as you've alluded to, that seemed to be associated with his mental health. So I think it's fair to say that I'm aware of that. We would share our information with the CPS, and the CPS clearly will come to their conclusions too.
And just to be clear, what's the role of the police and the CPS in relation to charging?
So we secure and preserve the evidence, we collect the evidence, we disclose the evidence to CPS, we work and did work closely with the CPS on this occasion, and then obviously we provided that information to CPS in relation to a threshold test, and the CPS charged with murder and attempted murder.
Can we go to decision 51, please? Referring to head of crime to deal with any threats made to suspect's family. Officers deployed to suspect's family as witnesses have had concerns raised by them for safety. Press have already been present at their address asking questions. Inference from family that police may have leaked to press. Just to give some background first, so we know on the 14th of June, 2 detectives visited the family members of VC, didn't they, and spoke to his family. DC
Dwell and DC Davis, yes.
And it's right that both VC's mother and brother gave a detailed explanation about him and their communications with him and gave you zip files and anything they had in relation to him.
Correct.
They gave personal family background information, including the date when VC obtained his Portuguese citizenship.
I can't remember that, but
yeah,
if it's in the report, I don't dispute it now.
Spoke about VC's paranoia around governance, surveillance and the like, and were generally cooperating, fully cooperating with the inquiries you were making and giving you the information before you eventually got it off phones and all the rest of it. They were giving it you straight away. They were concerned that an article published gave information around citizenship, and more importantly, that it had been given to detectives, or information had been given to detectives. Did you ever investigate that to see if anybody had leaked information? Because you say here this may be without foundation, but I'm just wondering if it was actually examined, the details of information that they'd provided and what happened with it.
So the detectives, when they came back, obviously we had a debriefing with the detectives to find out what the family had said. The concerns that are raised in that policy were reflective of the disclosures made to the detectives. The detectives believed, or had been told by the family, that the family believed that there'd been a leak or somebody had found out about information in relation to the family and or VC. As a result of that, and what I believe to be other leaks, because as the investigation went on, either through investigative journalism or through a leak or through some other means, I believed that somehow the press were getting hold of information. So that was referred to our Professional Standards Directorate by myself.
And it's extremely sensitive, isn't it, for suspect's family? They're not the suspect in the end. VC is the offender and the suspect, isn't he? Obviously.
Yes, and I think I do not want to cause offence to anybody, but equally, his family, in many regards, were also trying to deal with these tragedies themselves, and so, in one respect, were victims themselves.
Can we go, please, to entry 53, decision 53? And it might be helpful for you to have 53, 54 and 55 all on the screen because this is relating to the charging decisions surrounding VC.
Yes.
And we see, well, do you want us to take us through this? What happened from your perspective? I can read
Yes.
to remind you, but if you remember, tell us.
I can tell you
Yes.
exactly how it was occurred. So we were clearly working very hard, flat out, in order to secure the evidence to charge VC. We believed that we were there, that we were liaising with the CPS, and we were probably going to have a final wrap-up interview and then look to charge or invite CPS to charge. I then had a contact from Gold to say that there'd been media contact similar to other media contact that was suggestive that there were stories going to appear in the press that were going to undermine the investigation surrounding violence, mental health, and it could prejudice the investigation. Clearly, that gave me real cause for consternation and concern. I then spoke with Gold. Gold said, would we be in a position to charge, in as much that if it became sub judice, then quite clearly there could be no damage to the investigation. There could be then a time when we could liaise with families, and there was a suggestion that some of the media reporting that was surrounding it had been embellished. That's what I've used in my policy log. So from an SIO's perspective, I was left in a very difficult position where I believed that the investigation that we were working so hard to secure, charges for murder, were going to be undermined. On that basis, I've rung the family liaison officer to corral the flows together to say we may need to contact the families. I've then contacted the file officer to see where we were with regards to it. He'd informed me that Alan Murphy, the CPS lawyer, had verbally agreed to charges and was in the process of finalising it. I then got hold of the interview teams, the Tier 5, to say, stop interviewing what you're doing, get him out. We've got an agreement in relation to charge. I've then tried to contact the family liaison officer to tell her that we're going to start to look at charges in relation to it. You need to then, at the very least, update the families. I've then contacted CPS with a view to finding some advice about how we would obtain an emergency charge, whether or not we could do it without the written advice, whether or not we could do it through some emergency charge position. I'd informed her that Alan Murphy, I believed, had given us the authority to do it. She said she would try and get hold of Alan Murphy. She then tries to get Alan Murphy on the phone, by which stage we're in the process of getting him to the charge desk. I've then basically said, charge, believing that we'd had authority to charge. Sam Shallow then rings me back and says, you've had discussions around the charge, but Alan hasn't provided you with that verbal yet. He's waiting for the final CPS update in relation to the CCTV, albeit he's already seen it. I said, I think we've already charged. We had already charged, so I apologise to Sam Shallow for that. The written advice that subsequently came through was probably, I think, 40 minutes after the first charge. And so, therefore, technically speaking, I'd authorised the charge ahead of the written authorisation by about 40 minutes. Mm-hmm. So then I rang Alan Murphy, managed to get hold of him, and I apologised to Alan and said, I think, Alan, I've charged ahead of your written advice being received. In fairness to CPS, he was very gracious about it, if not angry, and I could understand his angst because, technically speaking, I had charged without his authority. And then we had a discussion about retrospective charging. And then he applied the Director General guidelines in terms of retrospective charge. So that was that, in a nutshell, how that all came about, all within a very short space of time.
Was it effectively, as far as you were concerned, pressure from the press that led to you charging then?
Yes. And also, yes, but clearly I hadn't been reading the press, but I'd had the conversations with Gold. So the press pressure had obviously come from press liaison into media team, into Gold, Gold into me, and then obviously I've had the discussion with Gold. I've then had pressure put on me, quite rightly, to try and safeguard the investigation. I've then, that's the train of discovery, for want of a better word. That was the next 45 minutes of real pressure from me as an SIO, making sure that there couldn't be anything that would cause a problem for my investigation.
Can we have a look at CPSE 0000600, page 1? It seems to be a note from Samantha Shallow on this topic to Cheryl Monk.
Just before you go to that, just so I don't think you've actually said who Gold is.
Oh, sorry, Gold was Assistant Chief Constable Griffin.
Yes, I'm just clarifying that so people can understand what's being said.
Sorry, Mark.
So this is a document from Samantha Shallow, a not for circulation in the event any issue arises to who said what and when.
Yes.
2:35 p.m. call from Lee Sanders said they wanted to invoke emergency charging procedures.
Yes.
Custody Sarge says they can only charge one offence. And then the third paragraph, the issue is that they've been contacted by the press who want to run an inaccurate story on the warrant case, overstating the position in terms of the level of charge, age, etc.
Yeah,
What does that refer to?
I don't know what that refers to, I'm afraid.
Well, we know, obviously, there was a warrant for his arrest, and in fact, you dealt with that at the beginning of your evidence today. But you can't remember having that conversation with her. It looks like she's recorded that.
I've had the conversation with Sam Shallow, absolutely.
About the warrant, position of the warrant not being effected.
I can't remember, I'm afraid.
And she says a lot of noise and other calls in the background. Is that what you might have said, a lot of noise in the background or other calls in the background?
Yes, there was lots of calls to and fro in between lots of people at this stage.
What did you understand as at this date, on the 16th of June? Had you got the Avato evidence yet about the attack in Avato? When did you get that evidence in?
I can't remember the exact times that we've had it, but yes. So in terms of Avato,
I think you went to the victims the next day, actually.
we went to the victims, we secured statements.
Yeah.
I think we spoke to Ali Parvez. I think we got the associated material to identify it was Calicaine. I think he'd been interviewed about it. So that would all been done by then, I would have thought.
So you did know about an offence and a warrant, an outstanding warrant in relation to the timing of that offence. So is that a conversation that you might have had, that you were worried about an inaccurate story on the warrant case or coming out?
When you say the warrant case, do you mean the Avato case?
I think it means the warrant, the Nottinghamshire assault on a constable, emergency worker, the warrant that's was
You mean the
outstanding.
Okay.
It was an outstanding warrant.
Yes.
It was significant, wasn't it? We've
There was an
agreed
outstanding,
earlier.
yes, there was the outstanding warrant. We'd investigated the Avato. I cannot remember now what other incidents that were relayed. But clearly, the warrant case. Well, the warrant case then must be the failed to appear warrant.
If we go, please, to decision 58 next. You refer here to it can't be ruled out that some media knowledge around the investigation may come from internal leaks.
Yes.
Can you see that?
Yes.
What were you beginning to think about leaks and what should be done?
So I believed that it could only be one of three options in terms of information that was appearing in the press. It was either a leak, whether that was in Nottinghamshire Police or another agency or partner. Investigative journalism, which there's quite a lot of evidence of intrusive journalism throughout the investigation and statements and CCTV being obtained before police liaison, or it had been leaked or passed on by families, which clearly at this stage I don't believe had happened. So my personal view was investigative journalism or leak. So therefore, as the policy says, as such, process needs to be put in place to reassure investigators this is not the case. In other words, we need to have some reassurance that nobody could be providing information.
In the decision above it, the 57 decision, you
Yes.
refer to interviewing officers, CCTV analysts. They've delivered services with incredible professionalism which could have emotionally impacted upon them.
Which policy is that, sorry?
Decision 57 above, can you see there?
I think you might need to go up.
Yeah, it is there, just where the cursor is now. They've delivered
Okay.
services with incredible professionalism which could have emotionally impacted upon them.
Yes.
Did you think at that time about putting something in place to prevent officers who were not for a policing purpose required to look at any footage or details of the case? What systems were in place, as far as you were aware, to prevent those having unauthorised access to information surrounding this case?
So from a homicide perspective, my concentration is on the homicide. In terms of any conduct or misconduct issues, then for me, there's an entire department that looks at that, so I'll refer it on. Is that the question that you're
No,
looking
it's
at?
what systems you have in the data that you're storing yourself, on Holmes or generally. How do you prevent people accessing material relating to investigation? You've got highly sensitive information, which you
Yes.
recognised in right-minded people was going to have an effect upon them looking at it.
Yes.
If What system does the police have? Does it have a notice at the beginning? Don't have a look at this
So-
unless you're connected to the investigation? Or what happens when you
Yeah.
try and access footage within the police not related to an investigation you're involved in?
So starting with physical barriers,
Yeah.
so clearly from the major crime perspective, we've got the Holmes account, which, as I described earlier, has limited access. The CCTV for this investigation, in terms of the dash cam footage, if I can explain it that way, was so sensitive that it did not go on what I would call the NICE system, or let's call it the force business as usual system, and it was retained within a small CCTV cell and lock and key. So there was an extra added operational security element to that. That was for the major crime unit, quite clearly. In terms of, if you think of, you're talking about wider body-worn video or other footage, if it was related to the inquiry team, and we've looked at some of the CCTV that we looked at earlier, that would come into the CCTV team, the CCTV office, locked and key, logged, secured. CCTV that could have been obtained, or body-worn video from perhaps wider audience, that would be logged on to the NICE or NICE system. My understanding in relation to access to that is it's not really practical for the functionality of the constabulary to limit access to some of that, but there are clearly protocols in place that if people look at things or search databases without a policing purpose, then clearly the disciplinary processes kick in as enforced by the Professional Standards Directorate in broad brushstrokes.
Can we go to decision 62, please? And you set out there, Montero remains a witness, request to be made for a voluntary search of his property. You detail this in your statement. If we can go to your witness statement, please. And it begins page 33. You set out all communications between them, and if we go to page 36, we see, which fits in with the timeline, VC saying, and you know someone who can accommodate me for a few days. This fits with when he's been evicted, doesn't it?
Yes.
And then you transpose calls at page 37 and 38.
Yes.
And it all fitted where the keys were and where you were told the keys were, that VC had the key to Montero's, that's right?
Yes, so the exhibits NGB 5 and 6 taken from VC in custody were provided to SO15 and they fitted the address for...
Yeah. And we see here that I trusted you at my home and you took my key and left with it. You got into trouble with my neighbour and now I'm here. Did you find out why or how VC got into trouble with the neighbour? He told, just so you're aware, Professor Blackwood and Dr. Mervis that he was threatened by a neighbour in that building with a zombie sword or something shortly before the attacks. Was that ever examined by you?
No.
And it was not anything you were made aware of, the police were made aware of dealing with VC at any point?
Not to my knowledge, no.
That can come down, thank you. '73, please, decision 73. We see defence have sought a psychiatric assessment which has now been received by the CPS. In short, it states that VC is fit to plead, defence of insanity is not available, partial defence of diminished responsibility, re the murders, is available. So this is the 29th of August, we've moved on. sorry, 13th of October.
13th of October, yes.
13th of October. Was this is the first time you commit this to paper, was that when you understood it to be the case that diminished responsibility was being firmly raised?
Yes, so there was an email received from CPS in relation to Leo McSweeney's report on the 2nd of October.
If we go, please, to 78, decision 78. You say, to ensure families are fully appraised as to the position held by experts and the implications this may have on judicial outcomes. What were you expecting here?
So, obviously the burden of proof had passed to the defence teams, and obviously Mr. Leo McSweeney had provided his report. The expectation was that that was not acceptable to the Crown, and we would be challenging that by means of prosecution report.
And as far as you were aware, were the families in any sense likely to anticipate that was the case or was going to happen before then?
Before that meeting,
Yeah.
they were aware that there was a history of mental health. The extent of that awareness was probably limited.
At 79, you say, will ensure that the flows are cited ahead of the team's direct family meetings as to the position held by experts and the implications this may have on judicial outcomes. Do you think it was fair to require the flows to be dealing with this issue with the families?
Yes, in as much that the flows are the communication between the inquiry team and the families. I do accept to a point that these are complicated issues that do require clear and precise input. And I suppose the question associated with it is, who is best placed to provide that update? And is that the police service, the CPS, or indeed could it be psychiatrists themselves? But in terms of family updates, the communication does come via the flow.
In a case such as this, do you think written communication with legal input, probably from the CPS, would have been better?
I think, in hindsight, yes, most definitely. I can't comment on the CPS position, but from my perspective as the SIO, more certainly, I do believe that I should have provided written updates to the families, most definitely. So, from my perspective, I can talk for myself, yes. From the CPS, that's a question really that they need to ask for themselves, for their organisation.
If we look at 81, decision 81, policy decision, mature assessment following family meeting with prosecutors 24th of November. I'm going to go to the details of that in a moment.
Yes.
But as the SIO, you've described very clearly earlier on your view that this was murder, calculated killings. When you got to this point, and the issue of diminished responsibility was raised, what was your view about that yourself? Did you feel you shouldn't have a view, or had your view changed? Where were you at?
I'm certainly entitled to a view, most definitely. I can concede that the position and the difficulties that the families were trying to grapple in terms of how could this not be murder, in terms of the behaviour that had been exhibited, were not dissimilar to the views that I possessed previously and continued to possess.
When you say continued?
Inasmuch that, from an operational policing perspective, did I still believe that the individual VC had provided elements of control, of planning, to what some members of the inquiry team would say were clearly calculated killings, where he, again, seemed to be exhibiting choices, didn't seem to be under duress. The CCTV showed him making decisions. I shared those concerns and continued to share those concerns. But I am not a psychiatrist, and I have to operate within the framework that exists. The framework that clearly existed here was that there were two psychiatrists with very little difference between their conclusions, both stating that there was a fitness to plead, insanity was not an option, that the partial defence of manslaughter on the basis of diminished responsibility existed, and that was their conclusion.
Can we go to, there's various minutes of this. I'm going to go to the CPS minutes if we can. CPSE 0010008 begins page 1. It's a meeting 24th of November 2023. It takes an hour and 3/4. All the people listed there, including yourself, Mr. Sanders.
Yes.
And if we go over the page to page 2, it's Kareem Khalil, KC, who begins stating that he and his junior deal with a lot of mental health cases, a lot of background knowledge. I was given an outline of what you want to discuss. I will answer as best I can, and then we see his setting out the position. If we can go to page 3, paragraph 2, he says, if one steps back and looks at the carnage he inflicted, it is not of any surprise for him to have acted as he did. He used a dagger on people unknown with no motive, then took a vehicle and drove into further victims. Again, nobody he knew and no motive. He then parked up and allowed his arrest. Seems extraordinary behaviour. Just that description, he then parked up and allowed his arrest, seems extraordinary behaviour. Did you know the circumstances of his actual arrest?
Only from, yes, in as much that the CCTV that showed his arrest.
Mm-hmm. What about the moment before he's pulled across, and then what happens when he's actually taken out of the van?
When he's tasered out of the van? Mm-hmm. Yes, so obviously I have seen that footage. I can't tell you exactly at what time and date in relation to it, but I have seen that footage, yes.
Well, the inquiry's heard evidence now about that arrest and the circumstances leading up to it. So tell me if you didn't know any of these things, and if you did, if you thought they were relevant when this was stated. So first of all, we know that an officer was following him when he was in the van with
Correct.
the blue light on.
Yes.
And the working assumption is he saw that and refused to pull over, didn't pull over, in fact went and committed further attacks.
Correct.
When he goes into Bentinck Street, there's a vehicle behind him, a police vehicle behind him.
Yes.
And there is one further down the road, but
Yes.
across the road.
Yes, driving towards, yes.
So when he's pulled over, as it were, there's certainly a vehicle behind him, not entirely clear yet, but we will be, I hope, when the vehicle crosses in front. So he pulls over. The officer who gave evidence surrounding the arrest itself says that when he walked behind the van, VC tried to reverse it. And he also had a knife in his hand, which they anticipated, obviously, was intended to be used on them as people arresting him and apprehending him.
Yes.
Assuming those facts to be right, that there are vehicles either side of him, that he has a knife in his hand, and that he tried to reverse the vehicle, seeing an officer in that space, would you describe that as parking up and allowing his arrest?
No.
When that was said, did you think, that doesn't fit? You might not know all the details and timings, but it didn't fit the picture.
I cannot remember now, and I cannot remember in the context of that being said.
If we go over the page 4, top paragraph, the summary is this. In the course of the night, he phoned his brother and sounded disturbed. His brother was anxious for his own well-being, said there was no indication that he would harm others. Again, we're due to hear evidence from his brother, but it's not the case, is it, that he was asserting to you at any point what risk his brother may or may not pose to others. He was saying he thought he was going to harm himself, but he never postulated he didn't pose any risk or harm to others, did he?
His brother?
Yeah, because he's being cited here. His
yeah.
brother was anxious for his own well-being, said there was no indication that he would harm others.
Yes, I think
Generally.
I think that's what his brother disclosed to the inquiry team.
On the day of the call being made, but not generally saying he would not pose a risk to others. You see how it's being cited there? Phoned his brother, anxious, said there was no indication he'd harm others. Both psychiatrists said there was no prior indication he could be a danger to the public. What's being dealt with there is the risk he poses to the public. And the suggestion is there isn't anything to contradict that. Is that how you read that or listened to that?
Well, he was certainly a danger to the police officers.
Quite. And even on the arrest, he was a danger to the police officers, wasn't he?
Exactly.
If we go, please, to page 9, right-hand side, we will be pointing out that he retained a level of understanding of what he was doing was wrong. He was driven by the level of psychosis. We'll seek to argue there are some cases, this is for 1 or 2 deaths, this is much more serious. Features of the offending that night, we will point to suggest the deliberateness of what was going on. He waited and hid, he followed and chased, he stole a van, he avoided road markings and targeted pedestrians. He slowed down for speed bumps. He knew what was going on around him. We could add to that, couldn't we, that he changed his clothes and footwear, changed his shoes, didn't he, for...
Correct.
And
just had weapons.
Just while I remember that, the Slazenger bag, you'd tracked that through CCTV, hadn't you? He'd come back from London with the Slazenger bag.
Correct.
Sometimes when he was taking money out of a cash point, he left it. He didn't always attend that bag. And although you were never able to retrieve that bag, you learnt that he'd taken it to London and come back with him and likely thought it had clothes in it. Is that an accurate summary?
Correct.
So, changing his clothes, changing his shoes, did you look at the shoes he had on before and afterwards, the change?
Yes, so I believe there were trainers before and shoes after, or boots.
If we go over the page to 10, Mr. Webber's straight on that point, isn't he? The van was stopped, he was tasered, they didn't have to chase him down and drive him into a wall. He said, I thought the police had to stop the van.
Yes.
Then you say, in terms of providing you with the full details, I'm happy to come and do that. He was followed by the police. He came to a stop. He was reaching for a weapon, which is why he was tasered. We're seeing you next week. We'll go through it with you if you want to.
Yes.
But in terms of his intervention in the meeting, he was right that was, I'm not saying it was deliberately misstated, but not fully understood at that point, was it? It didn't appear to be.
No, I think when you look at the flow logs, understandably, in terms of providing details, the families, we were guided by them as to when they wanted that detail. So by that stage, David Webber is right to say that because we'd only provided the most basic of details to him.
Well, now we've got fuller details. He's even more right, isn't he?
He's right to make the assertion, definitely.
Can we have a look? That can come down to HMCP 0000340, page 1. And it's your note to Samantha Shallow regarding issues raised by the O'Malley Kumar family surrounding, in the main, the psychiatric assessments surrounding VC.
Yes, so following...
Sorry,
yes.
yeah, you tell us.
No, so yes, so following that meeting, Mr. Kumar had contact with the family liaison officer.
Dr. Kumar, yeah.
Yes, and as a result of that, he'd asked for some contact with myself. I rang Dr. Kumar, and that there is, I would suggest, a summary of the concerns that he outlined, yes.
Particularly, more consideration needs to be placed upon VC and the date of the murders themselves,
Yes.
how he presented that day.
Correct. That was a key consideration for Dr. Kumar about how he presented on the day when the index offences took place.
And Dr. Kumar and Dr. Sinead O'Malley Kumar are not averse to stopping the process to ensure justice happens.
Yes.
You say, I've informed there has been professional curiosity exhibited and those questions have already been asked. What did you mean professional curiosity exhibited?
So that's professional curiosity from a policing perspective, in as much that the concerns that the families raised were not dissimilar to the concerns that myself and other investigators would also naturally ask. Mm-hmm. So we too had undertaken clearly lines of inquiry, as you'd expect, in relation to speaking to witnesses, the telephony, looking at the CCTV, elements of planning. And obviously that information had been passed. And then that had formed, no doubt, part of the assessment by the psychiatrists. And then obviously we had read the psychiatry reports to determine if there was any difference between them, and they were not.
And you, looking at this, couldn't give the families the copies of the psychiatric reports, is that right?
Yes.
So they were relying on the meeting and couldn't look at that for themselves. And you say, I wonder if we could go to Dr. Blackwood and seek reassurance, ask or see if he could add emphasis or to his analysis with regards to the initial presentation of VC.
So the request from the families was, could particularly from Dr. Kumar and his wife,
Dr. Sinead O'Malley.
Dr. Sinead Kumar, correct, was for copies of the reports, particularly bearing in mind their background. And so I have asked, that was the request, could they not have copies of those reports?
And if we go to HMCP 0000346, page 1, You agree a form of words, I think, ahead of a further meeting, listening to concerns of family members, like to pause in order to take them and the other families through the report of the prosecution expert. You see there's a need to revisit that, yes?
Yes, correct.
Same time, CPS are exploring which psychiatrists will be instructed.
Correct.
Prosecution team want to reassure all families Dr. Pelkwood is independent and is a leading expert in his field.
Correct.
Has been known to challenge defence reports. There's another meeting, isn't there, on the 7th of December. Should we go to that? NGPF 0008905.
Avon and Somerset, yes.
That's right. The police minutes of that, NGPF 0008905. We see there, Dr. Kumar states they've come to the point that they've had to understand the timeline to understand some of their questions. And there's a timeline that's been prepared, isn't there, that you go through verbally. Should we put that on the screen? NGPF 0009927. Page 1.
Yes.
So that's set out. At the 24th of May, there isn't causing the occupant of the flat to jump out the first floor window. There's no mention, I think it's further down actually, if we can go further down please. There we are at the top now. Causing occupant to flee and jump out the first floor window. No mention of sustaining back injuries requiring an operation. Was there any reason that shouldn't be in the timeline?
No, I think that was a précis of the medical police intervention that we'd uncovered as part of our analysis. Behind each of them, clearly, there would have been further details, but no, there's no reason why that's not in there.
Going back then, please, to the meeting itself, NGPF 0008905, page 2 this time. And you explain, third paragraph down, explained his hypothesis. Well, you tell us what you say in that paragraph. See there, SI explained his hypothesis.
So, as we've already discussed in the policy logs, obviously in terms of motivation for the attacks, clearly unknown. So we retained an open mind, and obviously CT was one of the initial hypotheses that was being examined. We found no evidence of an ideological footprint to suggest that terrorism was the cause of the assaults. So therefore we had to try and work out, well, what the hypothesis could be. There did not appear to be a rational motive as to why the individuals were attacked. And I put there, I described that as being a sliding doors moment with the two children being in the wrong place, wrong time, children being Barney and Grace. And then I put there, it was important to me as the SO to be sure that I was not being hoodwinked.
What did you mean by that?
That due diligence had been undertaken, and whether or not I was satisfied that there was nothing else that I could do in relation to the psychiatric reports.
Did that mean hoodwinked by VC, effectively, that he...
Yes, that So there's two aspects. One is, was there anything that I could do as an investigator that could provide information that could assist anybody else in terms of their assessment? And the second one was is there anything in terms of a difference between the reports, albeit from a lay perspective, that I suppose would allow any difference to be looked at? I hope I've been clear there.
Can we go to page 5, please? And the top of that paragraph, you say he went to visit, this is VC, an associate, left him with a key. Defendant believed to be sofa surfing.
Yes.
Actually, he was only evicted on the Friday, wasn't he? And you know, because you looked at all his addresses, searched, went to all the addresses, he did have places of residence. In fact, more than one on a number of occasions were cited.
Yeah, so he had an address at Burfoot Road.
Don't keep giving us the precise details of the address.
Okay, oh, sorry, apologies.
No, that's all right.
So he had an address. He'd been evicted from that address. The individuals at that address had seen him looking for alternative accommodation. In the inquiry, we had identified over the first 4 days 10 other separate addresses for him. My belief was he was sofa surfing. That's what I've used.
Sofa surfing suggests you don't have any place that you're associated with or living in, and he does have residences. We know when he was living with other students, we know when he is staying in some places. It's not like he never has anywhere to be. It's that he has multiple addresses, and sometimes it seems to be false addresses. Well,
yeah, I think that's fair. Perhaps the way that I've phrased it. So I've referred to him with my staff as a sofa surfer in the
which
briefing.
sounds to me someone who's homeless or doesn't have any accommodation at all.
Yeah, I think that's fair. I've used the term with my staff, sofa surfing and nomad. I suppose, yes, he was not a resident at the time of the attacks. He'd been evicted.
Very recently.
Yes.
Isolated, doesn't have many friends. That's what you were being told by family and indeed.
Yes. You know,
And when you looked at the students he'd lived with before, really didn't have any friends. And
no friends at all.
starved.
I'd agree with that, yes.
And you say here, defendant has no criminal history. I don't know who said that at that point. He's got no criminal convictions, but he certainly had history, didn't he, with the police?
He certainly had history, as we've seen in that timeline, yes, related to, obviously, his mental health.
I don't need to turn to the particular page, but Dr. Kumar, when you provided the precise details of the attacks, the number of injuries, said it was clear the defendant's intention was to kill with the description of targeted stabs. Then the defendant must have had the cognitive ability at the time to know what he was doing. That was his concern, given the brutality of the attacks and the multiple attacks and the walking off afterwards. Yeah?
And I think the officer who put together the CCTV compilation would probably agree with that.
Can we go, please, to page 12? And we see there, Dr. Kumar, further down into that paragraph 4 paragraphs in. Not enough focus has been given on that day in his behaviour, pre-planned, premeditated, malicious. Lucky he didn't kill others on his way up from London. Sliding door moment could have been anyone's kids and family. These were very clear from a group of parents. They're all in agreement, weren't they? That can come down now, thank you. They were all in agreement. Were the Webbers there throughout the time you presented the timeline?
No, they left. They left I can't remember the exact time, but about 5 o'clock, half
But it
5.
was clear from email communication, wasn't it? If we go to HMCP 0000385, an email
Yes,
from Dr. Kumar, page 2, sorry, Sarah, page 2. Really appreciated the effort made by the whole team to be present. So in the face of what was really difficult, courteous, pleasant, polite,
yes,
and then straight to the point with legitimate concerns. Would you agree?
yes.
If we go over the page 1, the same from Emma Webber. Thank you, Sanjoy, for providing all of this. Dave and I totally share the same exact concerns. The lapse of time between the evaluations.
Yes.
And if we can go to a family meeting, please. NGPF 0004150. Page 1. So NGPF 0004150, page 1. This is a meeting with the families and with their FIOs, FLOs, is that right?
Yes, that's correct.
DC Fiona McVie opens the meeting, reading the report of Mr. Blackwood and then of Dr. Latham. And there's various questions being asked. Over the page to page 2. Dr. Kumar, urine done. Appears to be under the impression then that urine may have been done, or we don't know, but that's referred to. And hair samples need taking for screening. What was toxicology through hair?
Yes.
You requesting that, Dr. Kumar requesting that hair samples should be done.
Yes.
We then, please, if we can go to CPSE 0009084, page 1 to 3. There's a further response to questions from Dr. Blackwood from the CPS. Did you feed through concerns to the CPS that then ended up with Dr. Blackwood? I don't need to take you to the details of this. I just want to identify the document. We go to page 1. Response from Dr. Blackwood. Can you tell us how this came about?
So I can't tell you what it came about. I suggest these are some of the issues that had been raised by the family members that probably resulted in an action from the CPS to take away to answer questions for the families. It looks to me as if it's a CPS document.
That can go down, please. And can we have NGPF 0000474, page 1? And this is a report from Detective Constable Neil Beddoe, dated the 30th of November 2023. Can you tell us the circumstances in which he produced this report, please?
I can't give you the circumstances. I believe that what Neil has done is, as the file officer, he obviously reads and rereads all the information that comes into the inquiry. And he's obviously provided some narrative around his views regarding the mental capacity of VC.
And essentially, this report recognises or suggests that intent and culpability can't be determined by psychiatric evidence alone, doesn't it? That's what it appears to be saying as he goes through it. Would you like me to take you through some of it?
No, not at all. I suppose what the difficulty that we have is that these are opinions of operational police officers, and they are views and opinions, but ultimately we do not have any medical training or expertise. They are observations.
And he sets out, I'm just going to take to some examples, page 6. We know from page 6, the last paragraph, that VC calls Ali Parvis from Sky Recruitment saying, I just want to make sure you've cleared all records of mine. He points out throughout this document various moments when decisions are made and effectively covering tracks.
Yeah, there is views, yes.
And at page 11, he says at the end, an aim he appears to have been building towards and preparing since he bought the knife and knife sharpeners back in 2022. VC has shown himself capable of lying to healthcare professionals, identifying what they want to hear to achieve his own ends. As Prof Blackwood states, I consider that despite the psychosis, he would have known the nature and quality of the acts and what he was doing was wrong. Would therefore consider he's not insane at the material time. He was capable of forming the intent to significantly harm others, whether the knife or with the vehicle.
Yes.
This was sent to the CPS, wasn't it, this document? Because we see, if we can go to CPSE 0001996, page 1. Do you know who sent it to them?
I can only presume that the file officer would have sent it through.
And we see, Michelle, sorry, missed out you below. I'm going to respond to this in clear terms today. Having reread it, it's a really poor piece of work. That's what Alan Murphy says, doesn't he? And
I can't see that, sorry, on the screen.
sorry, page 1, it should be. What's it again? Maybe. Sorry, can we try this? Is it 1996? Apologies. CPSE 0001996, page 1. Have a look at the email at the top. And then we go down. I don't recall any request to the OAIC, that's the officer in charge, Bedo,
Yes.
to prepare a report on capacity, given the report of Dr. Latham, where he specifically refers to the erroneous attempt to correlate capacity with diminished responsibility. This report seems to be of no value. So legally interpreted as no value. Did you get that feedback at the time about the officer in charge or not?
I can't remember, but what I would say is that ultimately they are decisions for the professionals.
Who are the professionals in that context?
I would suggest in terms of mental capacity, they are the psychiatrists.
That can go down now, please. Can we go to NGPF 0008791, so it's back to your decision log at 88. And we see at 88, by the 7th of December, having seen what's being stated in reports, Dr. Kumar wants clarification regarding toxicology, doesn't he?
Yes, he does.
And it may be easier to go to some of the original documents for this as well, if we can. So if we go to NGPF 0008888, page 1. This was dealt with in evidence yesterday, Mr. Sanders, the evidence recovery plan.
Yes.
And we'll see what the forensic strategy was. That's what was within the strategy. We know, in fact, that urine was never requested. VC was never asked to give a urine sample.
Right, so in relation to that, that evidence recovery plan is clear that it was to be asked for, but I do accept that it's not listed on the custody record, yes.
Well, that means it wasn't asked for, do you think, if it's not there?
Well,
I'm not saying you'd have got a different answer
No.
given what he was saying about blood, but he should have been asked about it.
yes.
And he should have been given the inference that would be drawn if he said no, right?
Yes.
That was never said to him either. What do you say to a suspect about sampling?
What you say is that a failure to provide it, it's about the adverse inference that could be drawn later on in proceedings if you fail to provide that sample.
And we'll come to the interviews shortly, but given that he knew exactly where his rights seemed to fall in terms of saying no comment, that might have been appreciated what that warning means, mightn't it?
Yes.
If we go, please, to HMCP 0000461, page 4. It's one of these where they go backwards with emails, but it's page 4 and 5. The email begins, samples, forensic strategy. You're explaining what the strategy was to the O'Malley Kumars, and you look page 5, what was requested. And what toxicology and samples were taken in custody. You say non-intimate samples. Can hair sampling be done of the defendant now to determine any drug use? You say no, this will not be done. The defendant has no history of drug abuse.
Yes. Yes, that's what I said there. And in hindsight, I've apologised in my statement for that. In hindsight, perhaps I should have obtained a copy of head hair whilst he was in custody. Yes, because to do so at least would have alleviated some of the fears that the families, in fairness being raised by Dr. Kumar, in relation to what could have happened in relation to the negation of the possible defence of diminished responsibility. So,
Dr. Kumar sends lots of the emails or communicates it, but we're aware that all are in agreement, weren't there? It wasn't one person raising this issue, there were 4 of them supporting it.
Say that again, sorry.
Well, both the Webbers and Dr. O'Malley Kumar and Dr. Kumar. So it wasn't simply him, it was all 4 people, although he was the mouthpiece in these emails, these particular ones.
yes.
So if we look, please, at HMCP 0000461, page 3. You've said in hindsight you could have done that differently or should have done, but at the time,
Yes.
you get an email saying, I'm reading it with some shock and horror,
Yes.
serious multiple homicide, a full cache of non-intimate samples. That would clearly have been preferable. He wasn't going to give you those, but the non-intimate, he could give you, couldn't he, irrespective of consent?
Yes, we could have taken them by force, and some we did take that way, yes.
Well, there's no reason to believe that you wouldn't have managed that in the custody suite, given everything else that was managed, that you would have been able to get the hair
Correct.
sample.
I think that's fair, yes.
You then, I think, follow up the value that there is of hair sampling. Is that right? You make inquiries about how useful that can be.
Yes.
If we look at NGPF 0008897. So we see on page 2, it's recommended to wait between 4 to 6 weeks after an incident to sample hair, ensures that the hair has had sufficient time to grow above the skin and to allow for any hair remaining on the skin after sampling. So what did you understand the value could be of hair sampling at the time?
So, in terms of the hair sampling and the advice that had been received, my understanding was that in terms of negating, which I think was the main concern of the family, the concept of diminished responsibility by self-intoxication, if we'd had a sample of head hair that could show that there was blood or drugs in the system, that could perhaps, by inference being done through voluntary means, then it could have provided a rebuttal to the concept of diminished responsibility. The reason why the evidence recovery plan asked for blood and toxicology, blood and urine, was purely for toxicology to try and negate that point, because the understanding that I and the crime scene coordinator possess would be that blood and urine would be the only means really to show what he had in his system then and there at the time when the index offences were taking place. And then we could use that as a means, if diminished response became an issue, as a means to look at that potential outcome in terms of examination of blood or urine for toxicology. The sample of head hair would not be able to provide an analysis to show that drugs or alcohol would have been in his system at a specific time or date. And so therefore, it would not have been able to have been shown that at the time when the index offences were taking place, we would not be able to show that there would have been drugs or alcohol in his system, and thereby not be able to negate the concept of diminished responsibility.
It would have assisted if it was a lifestyle issue, though, wouldn't it? If there are findings through hair samples of drug use, particularly where someone's denied or said they haven't used them, it's relevant to the holistic view.
I think that's a very fair point. At the time that we were investigating and all the work that we'd done around the inquiry, there's a complete absence of any reference to drugs or drug use or abuse. But I do concede, in hindsight, if a sample of head hair had been taken, then if nothing else, we would have examined it to show, in my opinion, the absence, or otherwise, but for me, the absence of drugs, which would have gone some way towards alleviating clearly some of the concerns that the families have expressed really eloquently in those emails.
And the officer in charge had recognised very clearly how VC had deceived the health professionals, not telling them the truth about what he was taking, when, what was going on.
Yes. I think there's quite a bit of evidence throughout in terms of the medical evidence that clearly the inquiry will hear, that he has made attempts to deceive. So I agree with that point, yes.
And that would be another reason for fact-checking what somebody tells you about something that's relevant potentially to their defence.
So yes, so I apologise that we didn't do it, and again, that's been in my statement, and I'll extend the apology particularly to David Webber and to Sanjoy Kumar. They are the individuals who, within the email, have raised, I would suggest, very eloquently, their concerns, that they believe that we just taken the opinion of a single person, i.e. VC, and that what was being read in the paper or in the press coverage was that he was an habitual user. I suppose my frustrations in relation to that, which in terms of my communication could have been a lot better as to why I wasn't considering it, were probably down to probably some frustration by myself, in as much that we didn't just take the opinion of a single person, we did huge amounts of work on the inquiry in order to try and get justice for the families. And I believed that we needed to tell the families the amount of work that we'd done, because that was always our aim as an inquiry team, to get justice for the families. And equally, in terms of references to the media, I suppose that's also a bit of a frustration, in as much that it seems as if perhaps the lack of information perhaps provided by the inquiry team, for whatever reason, whether that's the families didn't want it at a particular time, or when they were getting it then, was perhaps a bit of overload with the pressures that were coming on top, particularly with the psychiatric evidence, perhaps meant that a void was being filled by the press, which wasn't always accurate, and perhaps that may have caused some frustration with me, really. And it was never my intention to hurt or upset anybody.
And just to go back to the point of the toxicology, so that you're clear, Mr. Sanders, the inquiry's asked all of the students, flatmates, that people live with VC, and has not had any evidence from any of them about drug use or seeing him with drugs. The reality is, though, isn't it, the toxicology is an important factor in that, could have been an important factor, the hair testing.
Yes, absolutely. And I suppose what, on reflection, I would probably like to understand, if I can put it this way, from the inquiry's perspective, would be around the entire concept of diminished responsibility and intoxication. Are we saying that that defence can only exist at the time when an index offence takes place? Or are we saying that it can actually extend to a period of time that extends weeks, months, perhaps years, leading up to the time when index offences are committed? Because that does have an impact on the, I would suggest, forensic strategies that subsequently are deployed by crime scene coordinators and detectives. Because at the moment, the impression seems to be that to negate the defence of diminished responsibility through self-intoxication very much depends on what's in your system then and there. And if it's then and there when the offence takes place, then there are clear limitations with regards to complexities around analysis of head hair. Albeit, I do accept that it would have alleviated the concerns that were raised by the families, most definitely.
I think that may be a good time for
Yes, thank you. All right, we'll come back at 2 o'clock. Thank you. Yes, Ms. Langdale.
Mr. Sanders, just a few more questions from me. And if I may, NGP F000871, the decision log, number 91, decision 91, please. And we see if we put that centre 4. Press have been in touch with regards to previous assault on an emergency worker where VC was RFS. This was a message again reiterated with the family meeting. A warrant was subsequently issued for failing to attend court but never executed. The suspect was by then of no fixed abode. At the time of his arrest for the index offences pertaining to Op Hendricks, the warrant was still outstanding. Just the issue of no fixed abode. We know on the 24th of May, when that warrant should have been viewed and acted upon, he was at 165 Burford Road, the address that he was evicted from on the 11th of June. So he wasn't of no fixed abode, was he?
No, not on that interpretation, no.
So why did that appear in that entry, no fixed abode? What were you basing that on?
That's based on my assessment of him being, as previously mentioned, sofa surfer, nomad, no fixed abode. That's just how I've always described him.
Did you try and check or get the verifying information either way? Because it's very different, isn't it, not executing a warrant where someone's of no fixed abode, you get the impression of nomadic, wandering, not available to find, when in fact that was not the case at all here.
No, so I didn't do any chasing up in relation to that, no.
But you accept where he was at an address, an known address, it wouldn't have been difficult to find him, would it, for the police?
Yes, he had an address. What his intelligence footprint would have looked like for that address, I cannot say, but he would have had that address listed in as much that his rental bills would have paid for the previous 6 months, yes.
So, for the police, not difficult?
Again, without me checking the systems to find out what intelligence footprint he would have to that address, I can't answer that.
But you'd start with payments or other options of public information where you could get it, and you can get quite a lot of that, can't you, when you want to?
Yeah, you can make inquiries into anybody on police systems, other systems. Yes, I don't dispute that.
92, please. This is dealing with investigations against officers. You refer to viewing of body-worn footage, and you refer to PC Gel.
Yes.
Access to police data, full details will be required as to commencement. Did you know that was about WhatsApp messaging and the appropriateness of messaging and what was sent, as opposed to what's recorded there about unauthorised access?
I'd have to check. The answer is, I don't think so, because that's what I've written there.
Do you think there was transparency about the Professional Standards Department investigations to the families at the time?
I think it should have been communicated a lot better, absolutely.
What does that mean?
Well, the PSD investigations, I certainly felt there was a disconnect between the inquiry and PSD. So the PSD department have an appropriate authority, has delegated authority to make the decisions. And if they'd undertaken investigations, I would like to have thought that rather than getting notified at this stage as the SIO, bearing in mind the referral had gone in quite some time ago, that there would have been effective dialogue. From my perspective, there should have been better communications. From my perspective, my concentrated efforts, though, are on a triple homicide.
There are two issues around communication, aren't there? One is how timely it is, and two, how transparent and truthful it is. So separating those out in terms of better communication, were they timely enough? Were they given information when they should have been given information, the families?
The families in relation to the PSD investigations.
Yes.
From the update I've got from the appropriate authority, it's clearly evident that investigations happened quite some time before. So therefore, the appropriate authority should have made a determination as to whether or not they're interested persons, because if they were, and there was an investigation and misconduct happening, then clearly there's an assessment to be made about informing people.
So they weren't timely then, from what you're saying?
Yes.
And then were they transparent in terms of the information, both its adequacy and accuracy?
In terms of which particular case? In terms of all three?
Yeah, the one, but let's just focus on PC Matthew Gell, an example.
The answer to that is, I can't really say because I don't really know enough about it. In terms of Special Constable Skendrage, I was asked to make some disclosures surrounding that by the Assistant Chief Constable, which I provided to the families on certain dates in relation to the Special Constable being dismissed.
Can we go to decision 116 now, please? And this refers to the flows. Um, 116. Flows are now starting to have their integrity directly challenged by the family via the media reporting, who are directly being briefed by families.
Yes.
Cutting to the chase, the flows weren't being criticised by the families, were they? The decisions surrounding diminished responsibility, how the pleas were being accepted was the focus, not the support the flows had offered in a practical way around bereavements, grief, what they had to organise, which is a huge amount. I mean, the family is supported by those people.
I suppose if you were to ask that question of the flows, they would perhaps give a different opinion. And again...
Well, what was your opinion? You knew what the concerns were of the families, particularly surrounding forensics, particularly surrounding the pleas. And from what you said earlier, legitimate concerns, you thought this was a murder case, you say, right,
yes,
until these reports were obtained. So those were the essential concerns, weren't they?
Yes. But what I would say is that the communication, all those messages, seem to be wrapped up with wider messages of a lack of support, a lack of information, and the flows seemed to take that particularly personally and particularly badly.
Is that because they felt responsible for transferring information surrounding these pleas?
I think they took it as a personal attack on them. That's how I would see it personally.
What did you say to them? This isn't about you as individuals. I don't know. We'll hear from us to the extent that's necessary. This isn't about you. This is about the fundamentals. The fundamentals that they consider this is a murder case and we're not prosecuting for murder.
Throughout the inquiry, the flows, in my opinion, did an amazing job. They are very special people, and the flows deployed on this investigation, in my view, should be commended. I think you need to ask the flows if you want an opinion over and above my interpretation as to what's been disclosed to me by them. By the end of the deployment, as you can see from Policy Decision 116, they needed to be exited from the inquiry because of the impact on their own well-being. So they felt as if they were burnt out, and I believe they took a lot of the criticisms to heart.
So turning to my question, as the senior investigating officer, was it for you to say, look, this is how the case is proceeding through the criminal justice process, this isn't your essential role, move away from that, this is not a criticism from you, essentially, this is about forensics, your decisions as an SIO, prosecution decisions, court decisions, and we've seen conferences with leading counsel?
Answer, yes and yes.
So you did tell them that and you saw that?
Yes.
That can come down then, please. We know that the communications around the 14th of June secure Professor Blackwood to do a report for the prosecution.
14th of what, sorry?
June, about engaging, engaging him, reserving him, the CPS reserve.
Retention, you mean? Right,
yeah,
yes.
Well, potentially. You don't book someone in, do you, if you don't think you're going to potentially need them. That's what's happened on the 14th of June, the day after the attacks. The CPS have liaised with and said, effectively, if expert evidence is required, we'd like you for this case. That's what's happened. You know that?
I know it now, yes.
Yeah. When did you first find that out?
I honestly can't. I don't know.
Well, we can ask the CPS, but it's important. You're a senior investigating officer. We've seen you have conversations with the CPS immediately around the 13th, 14th of June, but you weren't clear that they'd already identified a particular expert should they need them.
No, I don't necessarily agree with that. No, I don't know who they instruct,
Right.
and why they instruct people. They're matters for the CPS.
Right, so that was for them. So they had provisionally said to an expert, but you didn't know who that expert was. Did you know they were going to conditionally book an expert for a particular case?
I honestly can't answer that because subsequently I do know, but I don't know when that would have been disclosed. Does that make sense?
As a senior investigating officer, would you get a report in a homicide case? Will the prosecution try and get a report closer to the events in time and before the defence have obtained their report in proceedings? Has that ever happened in your
Before
experience?
the defence?
Before.
No.
And why is that? Again, thinking out of the box, I know it's difficult, you say it's for the CPS, it's not for you, but you're a senior investigating officer. Aside from this case for a moment, if there's a situation where you have somebody in detention who you've interviewed, where you know mental health may be raised, are there circumstances where you'd encourage getting a psychiatric forensic assessment straight away, rather than waiting for the defence to obtain one and the court process and getting one further down the line?
No, because although you might be aware that mental health may become an issue, is in existence and may be an issue, the burden of proof lies with the defendant and the defence teams. So why would I seek to get a report in relation to that?
You'd see that as doing potentially their work for them to do that?
Well, defence teams, it's a matter for the defendant and his defence teams. It's not for me as a senior investigating officer to determine what the defence should be. So I would not, I can't see how I could interject.
And in your experience, do reports come months down the line in homicide cases? In other words, the events occur on day one and the report for the defence arrives many days later with an assessment, months later?
Yes.
That does happen.
In terms of, so I would suggest in this inquiry, notwithstanding the fact that the date of Leo McSweeney's report precedes his actual submission by quite some time, I don't think that's unusual. No.
And finally for me, just going to the interviews of VC, there are audios as well, aren't there?
Yes, so initially...
Don't worry, you clarified that. You
Yes.
didn't think there were in a suite, but there are.
Correct.
You have them. Are those ordinarily, were they provided to the psychiatrist, the audios, or not?
Again,
You don't know? Not
I don't know. That's probably a question for the Crown Prosecution Service.
Have you looked at the interviews?
Yes.
And the custody officer yesterday referred to VC answering non-evidential questions, but not being prepared to answer evidential. Can I take you to an example? There are many, but I'll take you to one. NGPF 0000308, page 1. This is an interview, Mr Sanders, 15th of June 2023. And if we go to page 2, please. We see halfway down, Adam, can you just confirm for me that you want to be called Adam throughout this interview? He answers, that's my legal name. Just checking, can you confirm the 5 people who have introduced themselves are the only people present in this room? That is correct. First and foremost, Adam, we have to speak about your welfare. You're fit and well to be interviewed, yes. Yeah, obviously, if this changes at any stage, as long as it's reasonable and they tell him about breaks and he nods his head. You have rights whilst you're in the custody suite. Those are, they set out rights. So they say you've spoken to your solicitor without police being present. He says that's correct. You are happy for this interview to proceed? Yes. Nods his head. If at any stage throughout this interview you want a further private chat. And then continues when he's asked, you've been arrested for a number of offences. most serious offences, which are murder. I'm not going to through every single offence with you. What I'm going to do is remind you under caution. He nods his head to that. You've nodded your head to me, Adam, is that correct? I do. That's on page 3. Sorry, we need to move to page 3. And we see you've nodded your head to me, Adam, is that correct about the caution? If we go over the page, please, to page 4. Like I say, Adam, you're here on suspicion of 3 murders. That's all set out. Would you like murder explaining in any other format before we get to the questions? He replies, no. No. Are you happy that you understand what murder is? The answer comes, I am. You are, and for complete and utter clarity, we're interviewing in relation to the theft of a white van. Do you understand the definition of theft? I do. Can you explain that to me in your own words? No comment. Then goes on about the belongings in the van not belonging to you. That's what we're going to cover in this interview. Are you happy with that? That's what you're going to cover. I am. So when it comes to his rights, access to solicitor, understanding the caution, each time he's prepared to answer non-evidential questions, yes?
Correct.
He's given an opportunity at page 6. See my role here and the role of Rory's and everyone's engaged in this inquiry to try and find out what's happened. Try and get answers to get justice for the people that have been murdered. My role in this is to interview you. My role is to put facts to you as they're presented so that you can comment if you wish. You're told in your caution you don't have to say anything, you know. It's been explained to you on several occasions. But if you feel there's an answer that you can give, I suggest now's the time to do it. If you feel you can add anything, even if it's just sorry, Adam, then I feel now's the time you should probably do it. Do you understand? He nods his head. Officer says you're nodding, and he says, I do. That can come down, please. Throughout the interview, that and others, the officers then put detailed facts to him.
Yes.
Show him pictures of himself. Ask him details of the offences that he has committed. And without exception, he says no comment.
Correct.
You've read many interviews in your time, I'm sure, as a senior investigating officer, and no doubt you conducted a few as well, years previously. When you read those interviews, did they come across to you as someone who knew what they were doing in those interviews?
It came across as someone who understood what they were doing.
Understood the process, understood what was happening, understood when to give a response and not.
Correct.
Those are my questions. Thank you, Mr. Sanders.
Yes, Mr. Maloney, thank you.
Retired Superintendent. May I just start where Miss Langdale has left off with asking you about the interviews? Did you have a supervisory role in relation to the interviews in the way that you did to the whole investigation?
No, yes, in as much that I'm overall responsible for it.
Yeah.
But there was a Tier 5 process, so a supervisor would have been allocated to oversee the custody process and interviews.
So, but in terms of your role, would you have, for example, reviewed what the product of the interviews at the end of each interview and see whether or not things were being done properly?
Not necessarily.
No.
Albeit I take responsibility for it.
Yeah.
Because as the SO, I take ultimate responsibility.
Yeah.
But I would have delegated some of the process, obviously, down to the Tier 5.
Yeah. But, for example, would you have satisfied yourself that you had no concerns about whether he should be interviewed at that stage?
Yes.
Yeah. And did you know that there'd been essentially there'd been no Mental Health Act assessment of him at that time because it had been refused by the L&D?
Yes. So it was fed back to me that he was fit for interview, fit for detention,
Yeah.
but there was no L&D assessment made.
Yeah.
Yes.
And if anything different to that, in terms of whether or not he was being fit for interview, somebody had said he's not fit for interview, you'd have paid particular attention to that?
Yes.
Yeah. At any time, did the solicitors who were present with him in the police station, did they ever indicate that he was not fit to interview?
No.
No. And you'll have been aware as well that there was an appropriate adult with him.
Correct.
Anything from the appropriate adults? No.
Nothing.
Can I ask you just about the decision-making around the acceptance of the plea to manslaughter on the basis of diminished responsibility?
Of course.
And in particular, I'd just like to ask you about a document that Miss Langdale took you to during the course of this morning. If I could use the shorthand as DC Beddoes report.
Yes.
Thank you. Can I ask, was DC Beddoes tasked to write that report within the team?
No, he was not.
No, it was of his own initiative.
Yes.
But as you said to Miss Langdale, it is a report which recognises that the question of intent and culpability is not just down to psychiatric evidence.
Yes.
Yeah.
But in fairness to DC Beddoes, he also says that ultimately these are questions for the court.
Oh, no, of course, that's what I mean by that. That essentially it's not simply the psychiatrists have decided this, so therefore. He says ultimately it's a question for the court.
Correct, yes.
Absolutely. And he highlights VC's capacity for rational thought during the 13th of June and indeed on the 12th of June.
Yes, and as I've articulated, I think that they were also thoughts and considerations that other officers also had. Yeah.
Absolutely. And the history of not telling the truth by VC during the course of his dealings with the psychiatric services.
Yes.
Yeah. And he describes that the attack on Grace and Barney was not a frenzied attack.
Yes.
May I ask, did his analysis of the behaviour of VC on the 12th and 13th of June broadly reflect the position of many officers in your team?
I think it's fair to say that there were a lot of officers who genuinely believed that this was an instance of murder.
Yeah. And even after having read the psychiatric evidence, what they thought, they looked at the psychiatric evidence, they looked at everything that they saw and were of that opinion.
Yes, subject to the caveat, of course, that psychiatric experts have the medical expertise to make the assessment, obviously, and we are operational police officers.
So they had their own views, but there was a deference to what the psychiatrist said as well. Understanding that they were the professionals.
Deference is probably not the correct word.
I don't mean a slavish deference. I don't mean, oh, you've told me what it is and I have to be deferential to you. I don't mean that sort of slavish deference. I mean that, of course, they were understanding that these were professionals and this is what they'd said, so they had to take that into account in their thoughts as well.
Yes.
Yeah. Did your team want there to be a trial to see whether the charge of murder was proved?
I don't think that when the psychiatric reports were received, that option was available.
Yeah.
And from a legal perspective, I don't think that was something that could be pursued.
No. No. Yeah. So, I just examine that slightly.
Okay.
Because essentially what you're saying there is, when I ask you, did some number of officers in your team want to go forward, your answer was, we couldn't. rather than whether or not they wanted to. And so can I just follow up with one question?
Of course you can.
Thank you. You got Dr. Blackwood's report on the 21st of November.
21st of November.
It's dated the 20th, you get it the 21st.
Correct.
DC Beddoes' report is the 30th of November, isn't it? Some 9 days later.
Yes.
Was that reflective of essentially officers wanting to have a rigorous assessment of whether or not the defence of diminished responsibility was, as it were, open and shut?
The difficulty that you've got is that the opinion being expressed by police officers is based on being an operational police officer, on our observations from the key lines of inquiry that we pursued that give us observational views, but to try and understand what was going on in that person's head quite clearly, we simply don't have the expertise to do that. So therefore, obviously, by that stage, we'd had 2 reports. Obviously, concerns have been raised by the families. There were concerns within the investigation team because they are logical questions they are simply logical questions to ask. Further reports, however, were received that ultimately were all saying the same thing. And they're all professionals, all providing that advice. So within the framework that exists, I'm afraid that framework takes us where we went within the criminal justice system.
Whatever you might have wanted, there was no option.
Well, it simply, if we take what you were suggesting is, should we have took that to trial, it would not have reached half time and it would not have got to trial.
I'm not suggesting that.
Okay, my apologies.
No,
sorry.
All I want to know about, because all I want to know about was were officers essentially, I'll ask you straight, were officers unhappy that it couldn't go to trial with all because of the preponderance of psychiatric evidence that essentially you had to do?
If I can answer it in a different way.
I think it's perhaps gone as far as it can, Mr.
I think, Mr. Murray, sorry, Chair, I think if I can answer it this way, there were officers who believed that he had committed murder.
Right.
Thank you.
And that's the start. Thank you, Chair.
Thank you.
Were you asked to have any input on the instructions of the psychiatrists?
From memory, no. And from an SO's perspective, thinking in a wider context, I can't for 1 minute think that we ever would or ever have been asked to assist with instruction in such a manner.
Okay. Just to clarify this, could we possibly have CPSE 40148? CPSE 40148. And if we could go to the next page, please. And the next page, page 3. Now, this is the letter of instruction to Professor Blackwood.
What was the date? Sorry, I missed the date.
If we could go back, I'm sorry I don't have the date on that, page 1.
Apologies.
So it's the 4th of October.
Yeah.
So to page 3 again, please. These are the documents that were sent to him. Police case summary, counsel's brief case summary, all served prosecution evidence, all disclosed unused material. The disclosed unused material includes a significant amount of medical information, and the disclosed unused material also contains the contents of the messages the defendant sent to his brother the night before the attacks. So that's the list. Were you aware of the process of these particular documents being sent? Were you involved in that?
No, I wasn't involved, but looking at the date, quite clearly that instruction must have come after the receipt of Leo McSweeney's report.
Yeah. Because Miss Langdale asked you earlier, the natural process of things is that there is a receipt of the defence report.
Correct.
Precisely. And so you aren't able to say what was contained in the download information that was sent to Professor Blackwood or the medical records or anything like that. You had no part in this?
No.
No. Thank you. And Miss Langdale asked you about whether or not the video recordings of VC's interviews were sent to Professor Blackwood, and you don't know about that either?
No, I'm afraid not, no.
Can I just ask you, in terms of your inquiries, were steps taken to explore VC's life and history prior to 2019?
No, not prior to 2019. I think from the investigations that we undertook and we liaised with the family, I think the history that we identified in terms of his mental health probably dated back to 2020.
Yeah. So essentially, from what you had from his family and from the medical records that were available to you, then really things start 24th of May 2020 with the first episode of the door being broken in. Is that a useful way of
I think that would be a fair summary, but yeah. Obviously the families may know more, and obviously the medical notes that you've got subsequently to the inquiry may be able to elaborate further. From an operational perspective, I'm not sure, even if there were medical records going back that far, what I would gain from going further back, personally.
Yeah. I mean, you can imagine the obvious question that comes back, Superintendent, is, well, unless you look, you don't know, do you? Yeah, and you're nodding.
I think what you're going to say is, did we extend our inquiries back preceding 2020?
Yeah. And
the answer to that is that in terms of mental health?
Mental health, but general background, so school records, GP records? No.
From my perspective, from an SIO's perspective and the homicide, no. I didn't see how the relevance of that was going to progress my homicide investigation at that time.
Because your homicide investigation was, it was very strong in terms of what might be described as the actus reus and mens rea of murder. The complicating factor was the mental health position of VC.
I think that is a fair assessment. Yes, Mr. Maloney, yes.
Yeah. So you had accounts, you had the records, and so there was. Is it fair description to say, well, we don't need to do that, to go back earlier, because we have what we need for the issues in the case?
I think it's what's a reasonable line of inquiry.
Yeah.
What's relevant, not just speculative, what's proportionate, what's necessary.
Yeah.
I've listed, hopefully, as CTI has gone through the open-mindedness and what I believe my hypotheses were.
Yeah.
And we've followed reasonable lines of inquiry to try and take us where the evidence led us. Yeah. If there is anything that sits outside that, then clearly I would have made an operational decision as the SAO not to progress it.
Yep.
And that would be listed, and I would have probably have decided it wasn't reasonable, necessary, or proportionate in terms of the homicide investigation.
Okay. Can I ask you about a couple of documents then?
Of course you can.
Can I please ask you about document CPSE 11979 to start with.
Okay.
This is from, we can see the date, the 6th of July 2023.
Yes. And it relates to an action.
Yeah. And we can see there's a GI, no need to give the name, but that stands for Graduate Investigator, doesn't
Correct.
it?
Yes.
And that at 3 minutes past 11, they had a telephone conversation with a named individual.
Yes.
That person attended a particular secondary school with VC.
Yes.
And between 2013 to 2014, they were a student at Pembrokeshire College living in a student accommodation.
Yes.
Where he's also a resident and believes he was a cleaner at the college. That during that time, aware of an incident, and you can read that, but it involves violence in an animal. Yep.
Yes.
Yeah. She didn't go further into this, as was looking after a child at the time of the call.
Yes.
And then if we could then please go to the next relevant document, which is a Nottingham police record, which is NGPF 304019. That's NGPF 304019. Thank you. And this is filed. We can see Action 556, Priority High, filed. And we see that the trainee investigator, is that right?
TITSD, is that what we're referring to, Mr. Murray? That's trace interview, perhaps take statement.
Yes. Thank you. Used to live with VC and describes him having mental illness since at least 2013.
Yes.
You see that?
I do, yes.
Yeah. And then if we go down the page, the graduate investigator has done updated 6th of July 11:33. Further details for witness. Statement not taken as witness resides in Wales.
Correct. Yes.
Yeah.
I don't think that's the reason why the statement ultimately wasn't taken.
It's not.
It's not. It doesn't read well, but I don't think that's the reason why the statement was not taken.
Indeed. But we clearly have somebody there giving information that, in the context of an investigation where you have, as it were, cut and dried actus reus mens rea, only complication is mental health, that they are suggesting there that this person had mental health problems as long ago as, 10 years before.
Yes.
Yeah. Why was there any reason as to why that person did not have a statement taken from them?
I suppose my view on that would be that how does that add any more value over and above the information subsequently obtained in the medical records and the updates from families in relation to more recent mental health from 2020, whether correct or otherwise? That's the rationale as to why that would not have been progressed.
That's why that wouldn't have been progressed, yeah. Because you had a situation which was very much 2020 based and you had enough information from there on.
Correct.
Yeah. May I just ask you this question in response to what you've just said, retired superintendent, and I don't mean any disrespect with it, but would you not have thought that, in fact, the psychiatrists who come to examine this man will want the whole medical history? And if there have been problems before, they need to know about that.
I suppose two things strike in relation to that, Mr. Maloney. One would be they would probably have access, surely, to all of the medical records in existence.
Yeah. And can I just stop you there for a second?
Of course.
You assumed that because you weren't involved in sending the instructions to the psychiatrist. You assumed that they would have
I had
everything.
that caveat, yes.
Yeah. Indeed, in a document that Miss Langdale put up, which was Professor Blackwood's response to concerns from Dr. Kumar that we saw before the lunch break. In that document, Professor Blackwood says we rely on what the police send us. So that's very much the understanding, isn't it, that you expect everything to be provided to the psychiatrists.
Well, the police reveal, CPS disclose, that access is that information is open and transparent. In terms of instruction, that's a matter for those who instruct. Equally, for those receiving that instruction, what they may or may not consider relevant, I suppose, is a matter for them.
Yeah. Your information was that there was a sudden onset of psychosis in 2020.
Yes.
Yeah.
Corresponding with the behaviour that manifests from
and that information came from the records of mental health treatment. It came from VC himself in terms of his interviews with the various psychiatrists, and it came from his family.
Correct. And obviously the associated police timeline that obviously manifests from that.
Absolutely, and I'll come back to that. Can we just now look at another document, which is EMAS, so EMAS, and then 602. Now, whilst that's being brought up, the first time that VC came to the attention of the police was on the 24th of May 2020 when he broke down a door. And then he was taken into custody, released, and then he broke down another door, and Feven sustained serious injuries as a result. So that's the context. This is the day before, the 23rd of May 2020. And it is, so it's just after midnight on the 23rd of May 2020, I think. Yes, we can see it in the top left-hand corner. So 000501. And this is an East Midlands Ambulance Service record, and it's about taking VC to hospital. Okay?
Yes.
Yeah. And then we see assessment time under impressions.
Yes, I can see
23rd of May 2020, midnight. And we see on details acute behavioural disturbance, mental health, complaining of chest pain and hearing mumbling. So that's the day before he first comes to the attention of the police. If we could go over the page, please. We can see on past medical history, down at the bottom, patient admits to having mental health problems in past, but would not say what. Not currently medicated for anything on questioning. Did you ever see this document, Superintendent? No.
No. Not to my knowledge.
Not to your knowledge. You've seen a lot.
There are a lot
but
of documents.
you don't remember it.
No.
But if you'd seen this, would you have investigated that, gone to speak to the ambulance personnel and found out what was going on?
Possibly.
Yeah.
Because you look at the date and the approximate dates. But without, a bit of the wider context, it's difficult to say. If it, as long as you're saying it predates those other incidents, then yes, potentially.
And talking about mental health problems in the past, but would not say what. It's important, isn't it?
Yes.
Yeah. Because, of course, you're aware as well of the record of VC masking symptoms, of not telling the truth about his mental health.
Correct. Or taking his medication. Yes.
And quite a lot of what VC said was taken as accurate by professionals who saw him, wasn't it? Medical professionals.
I don't know that. That's a question for the medical professionals.
Right. Well, you can see from the reports. I mean, I'll just ask you about that because you saw, just to be clear, you saw Professor Blackwood's report. You saw
His psychiatric report.
Psychiatric report.
Yes.
Well, Professor Blackwood only did a psychiatric report.
Yes.
He didn't do anything else.
No.
No. So you saw Professor Blackwood's psychiatric report, and a lot of what was said to him by VC, Professor Blackwood acted on, didn't he, and said, I take this, this is what he said to me.
That's what the report says,
Yeah.
but clearly they're questions for Dr. Blackwood.
100%. But what the question I asked you was, did medical professionals act on what VC said to them?
Yes.
Yes, and they did. Now, can I ask you now about something that Miss Langdale asked you about, but the incident with Bill Montero's neighbour on the 13th of June and what investigations were done in relation to that?
Yes.
We don't need to put this up, but at page 70 of your witness statement, at paragraph 183, it's right, isn't it, that you say, and have a look at it, sorry.
That's okay, I've got it here.
And we, in fact, it may be useful to put it up now, and that's WITN 359001. And it's page 70, paragraph 183. This is talking about the text messages and voicemails on the phone of, the messages that come from Mr. Montero, isn't it?
Yes.
Yeah. And we can see that there you say those text messages offer nothing of significance regarding the investigation. If anything, they reinforce the narrative of the actions of a lone and a man evicted from a property who was looking for a place to stay.
Yes.
That was your impression of
That was the interpretation, yes.
Yeah. But just one that Ms. Langdale took you to, I'd like to take you to it in full, please. This was page 37 of your statement, please, where this deals with a voicemail at 1:15 on the 14th of June 2023. So this is a voicemail left by Mr. Montero at 1:15 on the 14th of June. And it says, I also tried calling since yesterday, but this number is not going through. I don't know why. I really want to talk to you. Send me your normal number. I will call you on WhatsApp, on mobile WhatsApp. I really want to talk to you. Really, because I want to go to that house there, see what's going on there, see what happened and what didn't happen. What's more, you're telling me one thing at a time. If this turns into a police case, bro, and then over the page, I'm going to hand you over. Well, I won't lie to you. You can't get me into trouble, leave like that and think, yeah, it's okay, man. When you see this message, give me a ring, man, and send me your normal number so that we can talk properly. I have to know what's going on there, man. I trusted you at my home, man. I trusted you at my home. And you took my key and left with it. You got into trouble with my neighbour, and now I'm here waiting for you, bro. Come on, man. Did you... Mr. Montero was interviewed on the 17th of June of 2023, significant witness interview, wasn't it?
Yes.
Now, obviously, he couldn't be asked about that particular message because it hadn't been translated by then, had it?
Yes, correct.
And there's no criticism at all, but there's no interpreter present.
No.
No. Did you go back to Mr. Montero to ask him what that was about?
No.
No. At paragraph 78 of Professor Blackwood's report, I won't put it up, to save time, but this is Professor Blackwood's description of what is described as VC's current account of the index offences and their aftermath. He stated that he'd been threatened within the Lewisham building on the morning of the 13th of June 2023. That's the day that he travels up. He'd knocked on a neighbour's door within the building. In fact, that must be the 12th of June 2023, wasn't it? Because Professor Blackwood has that date wrong because he was in Nottingham on the morning of the 13th of June 2023.
Yes.
He stated he'd been threatened within the Lewisham building on the morning of the 12th of June 2023. He'd knocked on a neighbour's door within the building. The neighbour had threatened him with a zombie sword, telling him to leave the property. This had amplified his sense of threat. He thought to himself, the voices are not playing around. The voices told him that they were going to harm him and his loved ones if they did not do what they said. They said disgusting and repulsive things in his head. And then the day continues as described to Professor Blackwood by VC. It informs his later actions.
What's the source document? Sorry.
That's Professor Blackwood's report.
It's psychiatric
I'm just
report.
reading from it to
Okay.
save time.
Yeah, no, that's fine.
Yeah. And you got that on the 21st of November 2023. Did that cause you to revisit the voicemail with Mr. Montero?
No, we didn't, and that's obviously not been picked up, that association.
Yeah. Because that could have been very relevant to testing VC's account of his mental state that day, couldn't it?
Yes.
Because if he was telling lies about that, just to put it in bold terms, that's a serious issue as far as his credibility is concerned, isn't it?
Correct.
Can I just take you on to the charging decision?
Yes.
And you charged early following pressure from the press, essentially, wasn't it? They were going to run a story and you needed to stop that story being led.
Yes, I didn't want anything to prejudice my investigation, yes.
Yeah. And you told the chair and Miss Langdale that you were concerned about inaccurate stories in respect of the mental health of VC, his violence, and it could prejudice the investigation.
Say that again.
You thought that was what was going to be said. It was about to do with the mental health of VC, his violence, and it could prejudice the investigation.
Yes.
And that's at 11:55 this morning, page 73, line 16, should anybody need to look. You have recorded in the policy decision 53, and I'll no need to put it up, but you've said that the communication from press was that the press were going to run in the media a fake embellished news report that would cause serious reputational damage to the organisation, undermine public confidence in local policing,
yes,
and cause unnecessary suffering to families.
Yes.
Ms Langdale took you to CPSE 40600. If we could look at that, please. CPSE 40600. I'll just see. And we see, and this is Samantha Shallow. She's an experienced CPS lawyer,
Yes.
isn't she?
She is, yes.
This is on the 16th of June at 4 o'clock.
Yes.
You charged around 4 o'clock, didn't you, just before, maybe 2:35?
I'd have to check the times, yes. I'd have to check.
The paragraph taken, Ms Langdale took you to, the issue is that they've been contacted by press who want to run an inaccurate story on the warrant case,
Yes.
overstating the position in terms of the level of charge, age, etc.
Yes, so, yes, sorry.
Can I ask,
Yes.
how would, essentially, just going back to what you said in policy decision 53,
Yes.
how would stories about VC's mental health cause serious reputational damage to the organisation and undermine public confidence in local policing?
In as much that they would be reporting in the national press whilst our investigation is going on, which would cause issues to the investigation. That was what had been provided to me, and the whole point about initiating that, those contacts and that rush in the next 45 minutes, hour, was in order for me to protect my investigation.
What would cause serious reputational damage to the organisation and undermine public confidence in local policing is exactly that which is identified by Miss Shallow, isn't it? Which is that a warrant for his arrest was not executed for 9 months after it was issued.
Yes, but we knew about that. And that was what we tried to communicate to the families.
And what would cause serious reputational damage to the organisation and undermine public confidence in local policing is the number of dealings that there'd been with VC prior to his offences on the 13th of June.
Well, yes. I'm not disputing that at all.
Sam Shallow is an experienced lawyer, as you say.
Yes.
And what she's recorded there is not they're going to publish things which will prejudice the investigation. She's recorded that they want to run an inaccurate story on the warrant case, hasn't she?
Well, there were a number of stories that were going to be published. That is why I've been in touch with Sam in order to see what can we do in order to protect the investigation. So I've been completely transparent and open from my understanding. I've put it in my book. I've had a discussion with Sam Shallow, and she's put it in her notes with a view to progressing charge in order to protect the investigation.
In the policy decision 53, you, having said that they were going to run in the media a fake embellished news report that would cause serious reputational damage to the organisation, undermine public confidence in local policing and cause unnecessary suffering to families, you continue. The case, however, would be sub judice should VC be charged.
Correct.
That means nothing can be reported, doesn't it?
Yes, absolutely.
Because it's potentially a contempt of court to report anything after the charge, isn't it?
Correct.
Are you sure that you didn't charge to shut down the stories of police failings around the warrant and other investigations?
Absolutely not.
Can I finally take you to the press release that was issued by Nottinghamshire Police? And if I could take you to NGPF 0004531. NGPF 0004531. Right. This is a discussion about the press release with you commenting on that press release on the 17th of January,
yes.
2024. Yep.
Yes.
And the press release is further down. It's come to you from Matthew Jarram.
Yes.
It goes to Assistant Chief Constable Griffin, to you, and to another lady or man.
So, yes. So,
yeah.
So it's me, the Assistant Chief Constable, and Lynn Heath, who works in also, I think, corporate comms.
Right. Can we go on to the first page, first of all? I've highlighted below, this is what you say. Matt, thank you, it reads okay to me. I've highlighted below in yellow one section which I'd asked to be taken out, rear ANPR cameras. Other than that, it's fine by me. Thanks again, Lee.
Yes.
And, and I'll go to it in a second, but it went out, so we'll see. If we go to the next page, we'll see what you took out. And maybe the next page, actually. Should be in yellow. There it is. So
yes.
This is what you took out.
So I was asked to review, so from my perspective,
yeah,
I've been asked to review the factual accuracy of the narrative around the attack.
Yep.
And there was, I think there should be a quote there from me somewhere, and obviously I've looked at the quote.
And you've said, right, I've looked at the press release, it's all fine apart from the one bit in yellow that I want taken out.
Yes, the bit around the ANPR because of our police tactic, yes.
Yeah. And of course your input would be sought because you're the you're essentially the SIO, you've been in charge of the whole investigation.
Yes, so I think
detective aspects of the investigation.
Yes, so I think they're asking for my view on the narrative with regards the investigation, and a quote from me, I would suggest, yes.
So we can see on the second paragraph down, well, the top paragraph really, that where at around 5:14 he killed Mr. Coates before taking his white van and heading towards the city centre. He deliberately ran over a man in Milton Street. The Milton Street victims sustained multiple injuries. The other two victims were on their way to work, also suffered injuries. Treatment to the woman, all three were lucky to survive the attacks. Officers managed to track down the van and arrested VC in Bentick Road at 5:35 a.m, 91 minutes after the first 999 call. They didn't track the van down, did they? It was there in front of them attacking people.
Yeah, they followed the van, yes.
Yeah.
Yes.
Thank you very much, Superintendent.
Yes, Ms. Cartwright.
afternoon, Retired Detective Superintendent. Can I just clarify one point practically, first of all, please, around the Beddoe report and the commissioning of that, please? Could we have displayed CPSE 0001996? Sorry, 0001996, please, not 196. Apologies. Thank you. So this is an email we can see at the bottom from Neil Beddoe to the recipients recorded there, but what DC Beddoe has stated is, dear all, following our case conference on Teams on the 23rd of November 2023, I have produced the above report regarding any evidence of the defendant's mental capacity for your consideration as requested.
Yes.
And so would you see that that actually does suggest it was a document specifically that DC Beddoe believed he'd been asked to provide?
No, not necessarily, no. I don't accept that, no.
So just, sorry, I think if we have the bottom expanded, the bottom of the page, which is... So certainly Neil Beddoe from this email, the bottom of the page, believes that that's been what's requested of him.
I suppose what was the Teams meeting on the 23rd of November, please?
I don't know, that's why I'm asking you, because this is a document that suggests from the DC Neil Beddoe that that had been commissioned by him.
I don't think that report's been commissioned by Neil Beddoe. I think there's been a meeting with CPS on the 23rd of November. It would be helpful to know what that related to.
All right, thank you.
I can't answer any further,
thank
sorry.
you very much. That can be taken down. Can I then ask you questions, first of all, around the previous incidents, but motivation for the attacks by VC on the 13th of June?
Mm-hmm.
Now, obviously, you'll be aware that in VC's backpack was a part of an envelope that had the names of 3 of those that VC had lived with when he was involved in incidents which the police attended. So the envelope has Chris, Ryan and Sam's name on, and that relates to the January 2022 incident.
At Madison Court, yes.
At what, sorry?
Madison Court incident?
Yeah, that's correct. So Raleigh Park. And so with that being a significant document within the rucksack, was that factored into consideration as to motivation, that the previous incidents were very relevant to what VC was doing on the 13th of June?
When you say a note, it's a torn bit of envelope with 3 names on. Is that what we're referring to?
That's what I'm referring to.
Significant in terms of what? The 3 people that he used to live with at a student property?
Well, let's perhaps deal with it in this way.
Okay.
VC carried out the attack on Grace and Barney Ilkeston Road.
Yes.
Within eyesight and eye line of Raleigh Park.
Yes.
Before he'd carried out the attack, at about 3:30, he'd been on Middleton Road.
Yes.
Where he had carried out attacks on Sebastian.
Yes.
But also the attack upon the police officer in September of 2021.
I think he was obviously familiar with that area as a student that probably resided in that area.
Well, certainly immediately at 3:30, the CCTV captures him going down Middleton Road, which is the site of 2 previous incidents. But then when VC left the scene after the attack on Grace and Barney, he took a route that took him immediately to Brook Court on Player Street. And in fact, that's where he's not seen for about 8 minutes within Brook Court. And so could I ask you, as the SIO in this case, had you appreciated the significance of where VC was on that morning and where he went and the route he took, linked to all of those previous incidents?
I think it was obviously the area that he was familiar with within Nottingham, and obviously that area was also relevant in terms of some of the previous history. Coming back to the point about the note, obviously we spoke to the individuals on that note. and obtained statements from them. Over and above that, I'm not quite sure what the suggestion from you actually is.
Well, the suggestion is, you are the SIO.
Did I think that they were part of a wider issue where they may be subject to attack?
Well, no, the significance in terms of a motivation for VC on the 13th of June is all caught up with his previous incidents, and that's relevant to his intent and motivation as to what he's doing on the 13th of June. An attack on students and the routes he took linked to all his previous incidents.
Possibly.
Possibly.
In terms of?
The factors you considered as the investigator.
No, did I consider the 3 names on that piece of paper?
Yes.
No. No.
And can I ask
not to that extent, no.
And we know that you spoke to get statements, but were those 3 individuals actually told about that note in the rucksack?
I don't know, is the answer to that.
Because can I ask you, please, if we look at, we can see from your log on the night, the first one, the previous addresses is located. Perhaps if we look briefly at this first of all, NGPF 003635. So NGPF 003635. Thank you. And if we move forward through that document to page 6, we can see in that morning briefing, thank you, we've got a rundown of addresses including the warrant, but obviously the previous addresses where we know they're linked to previous incidents. So can you assist at that stage? Was that simply an address check rather than a proper analysis of the previous incidents?
Yes.
And can we then please look at your decision logs, please? NGPF 0008791 and it's decision 74, please. Thank you. Thank you. So we can see decision 74, which in fact I think it's a decision that's from about, we're in October now.
Yes.
And you provided a timeline of incidents.
Yes.
And I really want your assistance to what extent you really did look into and investigate those. Because we have criminal damage, 12 Player Street, then ABH, Brook Court, lady out the window, IP Feven, arrested and released as not fit, prosecute, marked off mental health. And just pausing there, but there's no detail there about the seriousness of that incident linked to what was on the occurrence for that attack on Feven. And so what I want to know is, had you appreciated and realised the extent of the fractures and the surgery to her spine with metal plates?
So to be clear, they were not re-investigations.
No, I appreciate
of the investigation. They were, they were part of a timeline for us to look at to try and establish his previous actions, behaviours. So there were documents, obviously, that sat behind these, but they were not a re-investigation per se, if that makes sense.
No, I'm not suggesting a re-investigation, but because this note is so summary, it's whether actually you, as part of the investigation, had fully appreciated the extent of these previous incidents.
In as much that we were trying to identify his behaviours and how his criminality was manifest from mental health, if that makes sense. We're trying to establish, was there any pattern of behaviour? Was there anything that could assist us with understanding motive, understanding his actions, anything that could help us progress the overall inquiry?
All right. And that's what I want to understand, is because we can see these addresses and we go on, we've got Brook Court, we've got the assault on Seb on Middleton Street, and I think we've then got the PC Pritchard incident, which is also Middleton Street, and the stalking then of Seb. But did you at any point appreciate, when you were doing the work as to where he went that day, the significance of these previous incidents and where VC was and what he was doing on the 13th of June?
Not necessarily. That they're all in a small area, and that area tends to correspond to a student area in the main and locations where he used to live. So I think that the hypothesis is that that was an area of Nottingham that he seemed comfortable with.
But I think it's more than that. On the sequence of events, he is at Brook Court for about 8 or so minutes that morning of the 13th of June.
Yes. Yep. So he's certainly familiar with that area, yes.
Can I then please move on to the next issue? And it's just picking up on questions you've been asked about Bill Monteiro.
Yes.
And if we could please have displayed your witness statement, WITN 0359001, at page 33. Thank you. And we can see that you've helpfully, thank you, included in the statement a sort of chronology of contact between VC and Mr. Monteiro,
yes,
spanning back from the 25th of April.
Yes.
And it's clear, isn't it, that from the investigation I'd identified that Mr. Monteiro used to live in Nottingham, and we can see VC asking him about if he's coming back
Yes.
here. I think they'd worked together in Nottingham. And you can see the conversation includes, you've referenced about VC being a loner, but certainly VC is detailing on these exchanges that we see that he was going to be going out with some friends. Then over the page, please. Continuing exchanges linked to trips to London. And obviously we know, if we move through, you've been asked about the significance of the exchange. We move forward, please, to page 37, about what had happened in the flat, the Fordell Road flat, when VC has obviously had some sort of incident with the neighbour. Now, it's right, isn't it, at no point has Bill Monteiro been asked about what happened and the incident to the neighbour. Certainly it wasn't dealt with on the interview on the 17th of June.
Correct.
And why was that not asked about?
It probably wasn't known by the attending officers at the Metropolitan Police.
But you as the SIO, knowing the significance of the encounter that VC had had with Bill Monteiro, essentially, he's come back from London, essentially with the bag that had the weapons in, and he was a significant individual, would you not agree?
Bill Monteiro?
Yes.
Yes, Bill Monteiro was a significant witness, yes.
But it's also significant that something has happened between VC in London and another person that's caused the extent of the concern in the exchange.
Yes, I think that's a fair assessment, yes.
But because, again, was that not relevant to what VC's intent and motive? He obviously has lost his accommodation in Nottingham.
Yes.
He's managed to secure 2 days accommodation in Fordell Road, and now something's happened with a neighbour in Nottingham that's caused him to, a neighbour in London that's caused him to return to Nottingham. And so it's part of the chain events that's driven VC back to Nottingham.
Yeah, I think that's fair, yes.
And so why was that not investigated as relevant to intent and motive and what had occurred?
It clearly would have been missed.
And then can I ask you another factor, because we know that VC returned to Nottingham with the keys, but if we please can have displayed the person of interest log for Mr. Monteiro, which is NGPF 0001671. Into your investigation was this following document of the 15th of June, and it's right, isn't it, that this document reveals that Bill Monteiro had very relevant markers, including for violence, and links to a gang called the Portuguese Mafia?
He does have markers in relation to that, yes.
And I think this document also reveals links to...
Ms Cartwright, I think it's not appropriate at this stage to go into that.
All right. Can I just deal with the address point then?
Yes.
So this document, though, also revealed that at the time of June of 2023, it was said that he still had an accommodation and address at Quernby Road in Nottingham.
I can't see. I'm sorry.
Well, I don't want to move it forward.
Right, okay, yes.
So
there's,
and Quernby Road, would you agree, is a road very proximate to where the attack on Mr Coates took place, but also had a previous link to an address on Mapley Road?
I don't know, is the answer without...
But again, would you agree that
that
they are relevant addresses linked to where VC went that day that should have informed the investigation?
I don't know what the links to those addresses are without looking at the report, I'm afraid, so I don't know what assessment has been made of those locations.
Right, and that's what well, at any point, did you make any investigation of locations linked to Bill Montiero in Nottingham on Mapley Road or Quernby Road?
So, again, without... I would have to check to see what inquiries have been made in relation to that. And I don't know the significance, because I can't see the document, but...
It simply records those two addresses. I think that, to be fair, the Mapley Road one is more historic, but certainly Quernby Road is said still to be a current address for Mr Montiero.
I think from the inquiries that we've done in relation to Montiero, that he doesn't have a current address in Nottingham.
Can you assist then in terms of VC's attempts to get into Sealyhurst House? To what extent you did investigations? The statement of Declan O'Connor references that VC was saying the name Aaron. And can you assist as to what investigation was carried out by you linked to that?
In relation to him shouting Aaron?
Yes.
None at all.
Now, you've referenced about mindset, but it's right, isn't it, that the investigation did reveal mindset material on VC's devices. He had the Buffalo shooting videos as well as the videos of the attack, the shootings in New Zealand.
They were on his the zip files, yes.
Yeah. And so would you agree that that is relevant evidence as to mindset that VC had accessed prior to the incident?
I'm not sure is the answer to that. Relevant in what way?
Well,
he's obviously got a morbid fascination with that material.
Well, I think on one of the assessments that have been provided by CT Police, one of those videos alone could have met a tax offence threshold.
If that was the case, then I'd have to ask CT why that wasn't progressed.
Can I then next pick up about the bag? In fact, sorry, before doing that...
Ms Cartwright, we're going to have to speed up, I'm afraid.
Right. So briefly then about the bag. It's right, isn't it, that you've
the Slazenger bag.
Slazenger bag that wasn't found. But I think we can see in the logs that it wasn't until the 15th of June that really it seems that it was picked up about the Slazenger bag. So it was almost 2 days into the investigation.
Yes.
Thank you. And then can I ask you, because there is a reference to a bag that was seen, and I know there's a gap.
A different bag.
A different bag.
Yes.
So the recording of an NGPF 7760, that's not...
Correct, it's a different bag.
Thank you. And then can I please then briefly just deal with the issue of candour that you've been taken to by Mr Maloney, but before doing that, just deal with the reference, please, at NGPF 000007. Thank you. Now this is, if we can see, if we go over the page, please. Again, these are emails that are being provided to you. We keep moving through them, please, that relate to the incidents with Sebastian. And if we go back one, please. So certainly you're being provided on these emails with chains,
okay.
the various incidents that happened with Sebastian. And so that's before you have been responding to the document that you had taken to a moment ago. If we could just display that now, please. NGPF 004531. Thank you. So essentially you are approving, as has already been dealt with, everything in the email that followed, save for the APNR. But can I ask if we move through this document, please? There's an only if asked section. Thank you. And if asked, sorry, if we could just go back one, please. Thank you. And if asked section about the warrant.
Yes.
Which gives an account about Nottingham's police's involvement previously with VC.
Yes.
And seeks to give an account about the warrant, but also summarise the extent of previous dealings with Nottingham Police.
Yes.
Which is almost an attempt to suggest that it had only been when assisting execution of mental health warrants, rather than accurately dealing with the previous incidents that had occurred with Feven and the residents of Brook Court in May of 2020. Why were you not identifying that this statement significantly omitted relevant information linked to Nottingham Police's involvement?
So, first of all, that's the goal strategy. It's nothing to do with me, that bit. In relation to identification of, what did you say, other incidents?
Yes.
The other incidents were identified, not perhaps necessarily in this document, but they've been provided elsewhere.
Well, that's what I want to know, because you're thinking to say this was for Mr. Griffin, but did you review this? And if we look over the page, we can see other assertions that were being prepared to give to the press about the extent of previous interactions.
They look like...
Which again doesn't deal with the Sebastian incidents that you'd had the day before, and doesn't deal with the full extent of what had happened. And so I want to know to what extent you read that.
That's obviously... It says that interviews with BBC, ITV, Sky and Channel 4. That's clearly in relation to the goal strategy in terms of media management. So that's being prepared for gold.
All right, so I'm clear. So you say that you're not responsible for anything, the if asked section. You've just reviewed the bit before.
And whatever's quoted to me, yes.
Right, and so, but if we look at one of your logs, certainly what you make clear under the necessity for transparency and candour with press, I think it's your decision 59.
Yep.
Would you agree that was at the heart of what should have been happening when giving statements to the press about Nottingham Police's previous dealings?
I think that has been disclosed to the press.
Pardon, the document has?
The previous dealings with the police have been provided to the press.
I'll take that up with former ACC Griffin. And then finally, the flow point. You have said that the previous incidents were updated to the families, including the issue with the warrant.
Yes.
That did not take place for the survivors, those who VC attempted to murder. And in fact, it was a matter that was only accepted in the submissions of Nottingham Police. And can you assist us to why those updates were not provided to the survivors?
Throughout, I have offered my services to meet everybody at any time, at any particular place, through the flows. That goes for the surviving families too. And at no stages was there ever a requirement or desire to come and want me to come and visit. If there was, then the services I've provided to other family members would have been provided to themselves.
Now, additionally, the request was made of you for 2 flows per family. Can you assist us to why the 3 survivors ended up with 1 flow between the 3 of them?
I don't. I suspect that as the investigation started, perhaps there was a resource issue and they were pulled off for other inquiries. I simply don't know. I can't answer that, I'm afraid.
Thank you. Thank you.
Thank you. Yes, Ms. Heaven, are you going to ask just a moment, Mr. Beggs? Ms. Heaven, do you have any questions or not? Pardon? I know, but she's got some questions. Right. Okay, well, I'm going to finish this. We'll have a break after this, so yes, thank you.
Good afternoon, Mr. Saunders. I ask
Hello.
questions on behalf of Alest and Elias Callacane. First topic, please, and it's very short, but it's
Yes.
in relation to the evidence you've given to on leaking to the press.
Yes.
Miss Landale has asked you about the concerns that had been raised by VC's family.
Yes.
And you've explained about your concerns.
Yes.
And I think your evidence was that you referred your concerns about leaks to the Professional Standards Department.
Yes.
I'll ask you about the entry in the log very quickly in a moment. But in terms of context, the specific concern that was raised on the 16th of June, just so you're aware, by Elias Callacane, was that information that they had given as a family to your officers on the 13th and the 14th, particularly about the Portuguese citizenship and when it had been obtained,
Okay.
that had appeared in the Telegraph the next day.
Right.
So just to be clear, were you ever made aware about that specific concern being raised by Elias? And I think it was raised with Josette Davis?
Yes. So Josette Davis provided information to me in relation to concerns from the family.
Mm-hmm.
I can't say specifically it related to that particular disclosure, but certainly she relayed to me that there were concerns by the family about information being leaked that would be suggestive of providing their location, for example.
Okay. Can I just get up your log then, please? So it's 308791, and it's decision 64, please.
Yes.
Okay, so this relates to your evidence, I think, which was that you made a PSD referral. Is that what we see here in decision?
No, sorry, it's a different.
Okay. Well, can I just ask you, though, about
Yeah.
this referral? So this is the 19th of June.
Okay.
Because this does relate to concerns. Just read it. There appear to be details of
Oh,
investigation.
sorry, policy 63, yes.
Yeah, sorry. Appearing in the press, for example, suspect identity, family location. This could be through investigative interviewing or through conscious or unconscious leaks to media outlets.
Yes.
Just pausing there, what is an unconscious leak to a media outlet? What do you mean by that?
Whether or not somebody could have been overheard talking.
Oh, I see. Okay. DS Buxton to liaise with DI Gareth Harding at CCU.
Yes.
So what was the tasking that was being given then to DS Buxton and DI Gareth Harding?
It was the fact that things appeared to be appearing in the press that either must have come from a leak or ultimately they've been obtained through investigative journalism.
Okay.
I needed to make sure that the investigation was secure and there wasn't a leak within it. So the referral went to the CCU in order for them to undertake whatever investigations they needed to do to maintain the integrity of my inquiry.
But were you specifically tasking them to investigate the concerns that had been raised by VC's family?
Not necessarily, no. No, I wasn't. No, it was about what was appearing in general in the press.
Okay. Moving on from that topic now, please. Just very briefly on your early thinking about the motives for the attacks. Ms Langdale's asked you about your entry in the log. We don't need to go through it. I'll read it to you. It's the 12:15 on the 13th of June, and that's where we see you setting out your favoured hypothesis.
Okay.
And I think this is the first time that you say nothing uncovered to suggest ideological basis or anything relevant to CT networks. You'd reflected on the dynamic briefings and you thought it was not an act of terrorism, rather violent acts of criminality by an individual or group of individuals. Nothing from the wider CT network, all information suggestive of criminal acts, mental health possibilities. So this is very early on.
Yes.
I think it's 12:15 on the 13th.
That wasn't obviously conclusive, but that's
No,
where
I
was
appreciate
headed,
that,
yeah.
keeping an open mind, clearly. Had you had a briefing from wider CT networks at this point?
There was a CT SIO embedded with the investigation, so we would have been talking
Yeah.
quite regularly, yes.
So there was nothing coming from them of relevance at that point?
Nothing that's been made aware for me, no.
Okay. Now, you've referenced a briefing there. Were you getting a briefing on VC's mental health history as early as 12 o'clock on the midday 13th?
No, it would have been intelligence work that started to be drip-fed through.
Okay. You've been asked by Ms Langdale about when you came to know about diagnosis of paranoid schizophrenia. Just to be clear, is it your evidence that you didn't know on the 13th of June that VC had this diagnosis?
I would have known he'd had mental illness. I can't say for certain that he would have been diagnosed with paranoid schizophrenia, no.
Okay. Did you know about the outstanding warrant on the 13th of June?
That would have been the briefing document. I would suggest yes.
Did you know...
Or the 14th, one of the two, but it will be listed, yes.
Did you know that VC had been detained on a number of times under the Mental Health Act on the 13th of June?
Without checking the briefing document, I don't know when I would have been told about that or known about it.
Well,
but it will be listed on the Holmes document.
So that, if we wanted to find the answer to that, we'd look on Holmes, would we?
Yes, I would have thought so, yes. Document 3.
Okay. Very briefly, on the 14th of June, so moving forward in time now, the inquiry will hear from Alan Murphy, Specialist Prosecutor for the CPS. He describes a briefing at 9 a.m. on the 14th of June, and he says it was clear that mental health was undoubtedly going to be a feature of the case.
Yes.
As a result, he makes contact with Dr. Blackwood. He says we were also briefed by counter-terrorism police. All indications from those briefings were that this was not a terror-related incident and that mental health issues had already been identified. Were you at that briefing?
I can't remember if I was at that briefing, but I certainly spoke with CPS that day, and I don't think that's inaccurate what you've said.
Okay. So essentially from 9 a.m. on the 14th of June, there was nothing coming from CT? No evidence at all?
No evidence of CT involvement, yes, but they were still involved in the inquiry, yes.
I appreciate that. They're still doing forensics on the phone, I think.
Yes.
All the evidence was pointing one way, that it was a mental health related
Or
attack.
crime.
Or crime.
At that time, yes.
Okay. Moving on then, and this is, you've been asked obviously a lot of questions about your forensic strategy. I don't want to go over that again. Just want to ask you about your reasoning in the log for the decisions you took on samples. We won't bring it up, but it's decision 89. I'll just read out the key bit. You say this throughout, and just to be clear, this is an entry from the 12th of August at 12 o'clock lunchtime. Throughout this investigation, there's been no suggestion at any juncture that VC has ever taken, been linked to, or associated with anything to do with drug misuse or abuse. Consequently, this was and remains not a reasonable line of inquiry to pursue. Actions follow evidence, not speculation or assumptions, no matter how well intentioned. Now, you've accepted today, in hindsight, that you should have taken further samples, and I think you said that would have been to allay the concerns of bereaved. But putting hindsight to one side,
excuse me,
your job as an SIO was to follow the evidence and pursue reasonable lines of inquiry based on that evidence. Is that correct?
Yes.
And bearing in mind you had absolutely no evidence of drug use by VC, is it right that in respect of this issue, that is exactly what you did?
Yes, I had no evidence of drug abuse, that's correct.
Thank you very much. Those are my questions.
Yes. Mr. Beggs, questions, not points. Thank you.
As quickly as I can, Madam. Scenes. Did the Golden DI preserve all the scenes to your satisfaction?
Yes.
Do you accept that the issue of the outstanding warrant, the previous interactions between Nottinghamshire Police and VC, and any misconduct by any police officers were matters the families plainly had to be told?
Yes.
And can you remember when you first raised those matters with the parents of Grace or Barney?
In relation to which?
Forgive me, in relation to the failure to appear warrant and the previous interactions. I'll come on to misconduct later.
Okay, so in terms of the failed to appear warrant, that would have been at the SAO visit for the Amali Kumars, which would have been I think the 22nd of August.
Thank you. And for the Webbers, please?
That would have been the SAO visit with the flows, which would have been the 12th of September.
And was that verbal?
Yes.
Yes. Can we have up, please, WITN 0289004? I said, thank you very much indeed. So that's a meeting on the 7th of December 2023 at Avon and Somerset HQ.
That's correct.
Police HQ. And whose request was it to meet there?
That was the family's request.
And on that occasion, did you, as these minutes demonstrate, go through the previous interactions between Nottinghamshire Police and VC in some detail?
I did, yes.
And if we can just check that by looking at page 12 of that document. To save time, do we see that on page 12 you start in May of 2020, 24th of May, and then if we could just look very briefly at page 13, and we can see 13th of July 2020, 5th of July 21, MI5 on the 35th of May 2021, and so forth.
Yes.
And you worked through, if we could go to page 14 in the bottom half, please. You worked through and included the Avato matter in Leicestershire at the very bottom.
Yes.
And as can also be seen, the warrant issued for the arrest just above that.
Correct.
But it's also clear, in my haste, I don't want to overlook this, that Emma and Dave Webber had in fact left at about 17:45.
Yes.
Now, could I also have up, please, separately, NGPF 0009927. And is that the timeline that runs to just over 4 pages that you used to inform the discussion with the parents that I just took you to in the minutes?
It is.
And we can see it's colour-coded for NHS information or police information. I think that's how you've done it.
Yes, that's correct.
And because the Webbers had missed some of that, is this right that you saw to it that those minutes, the very lengthy minutes, were sent to them afterwards?
That's correct. They were emailed to them by the flows.
And that is NGPF 0008622. And if we look at the date at the bottom of that, we can see it's the 17th of December at 10:13. And then turning over to the second page, that's to the Webbers, we see that the third item attached by the FLO is notes of the meeting 7th December 2023. Do you see that?
I do. That's correct.
And so, even if it may be said fairly that that was late in the day, there was a detailed exposition of both the previous interactions and the failure to appear warrant.
That is correct.
May I then turn to the third matter that you accepted the families were entitled to know, and that is the misconduct by some officers and staff, yes?
Yes.
Is the short position this, that there was confusion and muddle as between you and others within Nottinghamshire Police in transmitting that information?
Yes.
And is the short position from your perspective that perhaps the learning is the SIO, who is dealing with the homicide side of it, shouldn't perhaps be troubled with matters that ought to be dealt with by others for whom it is a prime responsibility?
Absolutely.
Because the appropriate authority is the statutory person that has to deal with giving information to people who are entitled to know it.
That is correct.
But do you accept that you may have contributed to the muddle and the mess that unfolded?
I do.
Thank you. And we're almost concluded. You were asked some questions about transmission of the awful message to the loved ones of the victims.
Yes.
And you made a number of times, you made reference to validation.
Yes.
And were you there referring to, first of all, even if it appears obvious, it is critically important to ensure that you have got the identities of deceased persons?
Yes, absolutely.
Because it's an unhappy fact that the police have made mistakes in that regard in the past, have they not?
They have, and mistakes were also made on this occasion, yes.
Correct. And secondly, as important as knowing the identity of the deceased, you also need to know carefully the dynamic of the family to ensure you get the right next of kin.
That is correct.
And ideally, you would do this through an FLO in person. That's the ideal.
Yes.
You were not able to achieve the ideal in this situation.
That is also correct.
Because of social media and other media risking the facts coming out before you could inform the families.
That is correct.
Yes. And finally, in relation to the emergence in early October of the potential plea of diminished responsibility, did you, as Policy Decision 81 might suggest, did you champion the family's position so far as you professionally could?
Yes.
And did you maintain that position so far as was responsible?
So far as that was responsible, that is correct.
And is the short point this, when it emerged that every psychiatrist stacked up the same way, was there anything more you could do on that front?
No.
Thank you very much.
Yes, thank you. We'll take a break now. I'm afraid we're only going to take a 10-minute break because we've got another witness that we have to complete today. Thank you. Luckily, no spilt water.
Good afternoon,
Yes.
Chair.
Can I just say before we hear the officer that this officer is audio only and there's to be no photography or use of any video. Thank you.
Can I please call PC Jonathan Speeden?
Please repeat after me. I do solemnly.
I do solemnly.
Sincerely and truly.
Sincerely and truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth. And nothing but the truth. Thank you.
Thank you, PC Speeden. You should have in front of you a witness statement dated the 17th of February of this year. Is that right?
That's correct, yes.
And that has a URN of WITN 0407001.
Yes.
Can you please confirm that that statement is true to the best of your knowledge and belief?
It is, yes.
Thank you. PC Speeden, you joined Warwickshire Constabulary in March 2001, is that right?
Yes, that's correct.
And you've been an authorised firearms officer since 2016?
Yes.
So 10 years as an authorised firearms officer?
Yes.
You've not only completed the initial firearms course, but also the Operational Firearms Commanders course in 2021, is that right? Can you briefly assist us with what that course involves?
Yes, so that course is a 2-week course. It's a course for officers in the operational firearms world that are competent officers, and it will take you through to being qualified to be an operational firearms commander. It has tabletop exercises where you will go through planned jobs and also through scenario-based training as to what we would deal with in the real world, so we can prove that we're competent in dealing with firearms deployments, which ends in a final couple of days of exercises where you are assessed on your capability.
And presumably you passed that assessment?
Yes, I did.
And presumably that also includes the College of Policing's APP on armed policing?
Yes, it does.
Does it involve guidance in terms of search techniques? And we've heard zoning, for example. Is that included in the training?
Not in the OFC training, no. It's something that I would have been previously aware of just from my operational competency over the years.
And prior to 2023, had you put into action your training as a firearms commander in respect of any significant violent incidents?
Yes.
Can you give us an indication of how significant your previous experience was?
Unfortunately, there's been many incidents. One maybe of a similar nature would be when I was working for Dorset Police. That related to a stabbing in an urban area during the middle of the night, which that armed deployment lasted for, I think, was maybe 7 hours. That entailed searching for the subject whilst information intelligence was being brought in, as well as building searches.
And most recently, you've completed the firearms instructors course, is that right?
Yes.
And what does that involve, briefly?
It's a 7-week course, a residential course where they take you through not only tactics that you will teach to initial students on an initial firearms course, but tactics for your normal basic firearms training, which competent officers would go to the firearms training world. Maybe, I think on a rotation of maybe every 9 weeks you would have to teach competent authorised firearms officers. That course will take you from not being an instructor to being a qualified instructor at the end of it. It goes through modules that are within the armed policing content that we need to teach. It goes from classroom-based assessments, range-based assessments, and also exercise-based assessments.
Would it be fair to say that you are one of the more qualified of your peer group?
Yes.
And you're currently part of the Armed Response Unit in Derbyshire, is that right?
That's correct, yes.
How would you describe your general approach to your job in respect of a major incident?
Professional.
Do you always prefer to be armed, or do you weigh up, for example, the necessity of being armed or something else?
No, it has to be on a necessity. It goes on information and intelligence.
Are you more prone to wanting to be armed than your colleagues, for example? Are you more prone to wanting to be armed? There may be a suggestion that firearms officers like being armed. Is that your experience?
No, not at all. Like I say, we always carry a sidearm, so we are always armed with that. But when it comes to firearms deployment, it's not something that I would want to do unless the necessity is there to do it.
And do you, as a firearms officer, prioritise the interests of other firearms officers over the interests of the force in general?
No.
I'm going to move on then to the events of the 13th of June. Can we please play NGPF 304724?
Shot 4-1. 418.
Yeah, over.
I take it we're not looking at authority to deal with the offender.
Yeah, priorities the victims initially, please. Potentially got a second victim, a female, sat on the other side of the road.
So this is just one call at 4:08. Could we please bring on to screen your witness statement at page 11? It's paragraph 21. I'll just read to you a section of your witness statement. At paragraph 21, you say at 4:11, so the message we heard was 4:08, so a few minutes after that. You believe you had already asked the force incident manager if he would be authorising the deployment of firearms. This was not given. Whilst this incident was taking place, I asked several times if there would be authority for the deployment of firearms officers. I can remember that I had asked at the time of initially travelling to the incident, and then when I updated the force incident manager that there were 2 victims, not 1 victim, as originally reported, and that both had multiple stab wounds. Looking back at that, is that paragraph correct, that you asked several times in respect of armed authority?
Yes, that's correct.
And you've set out in your witness statement that in your view the relevant criteria were met. And you've also set out what you consider to have been the benefits of armed authority. The first is that you would have been able to protect those who were actually at the scene if the perpetrator had returned to the scene. Is that right?
Yes.
And then the second is that you would have got the other authorised firearms officers released once there was sufficient medical staff at the scene and commenced an armed search. Is that right?
Yes.
And perhaps if we could turn over the pages to paragraph 28. It's that second reason that I'd like to really focus on. You say at paragraph 28, if the authority had been granted and there was sufficient medical staff at the scene, I would have got the AFOs released quicker, as they now had another role to perform, and we would have commenced an armed area search for the subject. We know that the first ambulance crew arrived at around 4:10. The cardiac arrest leads and specialist practitioners arrived at around 4:13. The duty commander and cardiac arrest lead arrived around 4:19. A second ambulance crew at 4:20. And the doctor and air ambulance at 4:20 as well. Bearing those in mind, what kind of time do you think it's likely that you may have been able to commence a search with the other AFOs?
That's difficult to say. I know at the 4:20 time you stated there that I believe I was forcing entry into 316 Ilkeston Road. I would have just had to have the conversation with the medical staff there. Obviously, I'd already been told that, and rightly so, that the victim's medical aid was the priority. I don't disagree with that at all. And from my recollection at the scene, and having come out of 316, my AFOs were still very heavily committed with medical treatment. It would have been down to a professional discussion with with what I would say are the professional medics there, like you say, the EMAS, the air ambulance, as to if those officers could have been released as soon as possible, because, as I put in my statement, there is another task, and the task is we are armed officers, and that would have taken precedence then if they could have been released.
And perhaps we could listen to some of the talk groups thereafter. If we could start, please, with NGPF 304732. We're just going to play the first 29 seconds of that, please.
Shot 418.
Yeah, over.
I know our priority is the victims at the moment. My only concern is the offender. We have an unknown whereabouts for him. It's unknown if there's going to be any future potential victims or that the offender might refer to scene.
Yep, Oscar 1's listening to you.
We are at scene now, EMAS here as well.
Now, this is 411, so it's before that 420 mark,
Yes.
and we'll get to beyond 420. But you were raising concerns about the offender's whereabouts at that stage over the radio.
Yes.
Can you tell us what was going through your head at that stage?
Yeah, so the original report, I was aware that it was a victim that had been stabbed just prior to my arrival, excuse me, on Ilkeston Road. It was confirmed by another officer, I don't know who, at the scene, that it was a double stabbing with multiple wounds. So the information and intelligence had already changed for me at that point. What I'd already thought could potentially be a firearms deployment because of a stabbing to a single victim, in my eyes, was now even greater. What I could see on my arrival at the scene was that there was multiple people there giving medical aid to two victims, and in my eyes, they all looked vulnerable. And I mean that from the point of view that I didn't know where the subject was. My operational training from an armed response point of view is to be 360-degree operationally aware. I knew Ilkeston Road was a busy street. The last known report I'd had of VC was that he was making his way along Ilkeston Road. However, I'd come in from the city down Ilkeston Road and not seen him. So my thought at that time was, has he gone up an alleyway? Has he gone into a building? Or is he simply hiding? And all those people, for me, were just a potential another target for that individual.
And you were concerned for those who were present at the scene.
Yes.
Were you also thinking that it was necessary to carry out an effective search at that stage, or not?
It was important and imperative that the two victims received the medical attention that they deserved and required, but always the subject is a major focus. Because, and I think I've highlighted in my statement, is that for me, with processing the information and thinking of an armed deployment, is that there are potential future victims out there. Somebody's done something already to two individuals. It didn't mean to say that they possibly couldn't do something else.
We've heard reference to the possibility of a robbery gone wrong. Did you have anything in your mind as to what might have happened?
No, I don't like to draw conclusions. It's too early to say at that point. I just like to go on the bare facts that there is somebody that, in my eyes, is dangerous because they've inflicted such injuries and they've got to be in possession of something that's lethal.
I'm going to play some more messages over the talk group, and these are after the 420 period, so they come around 424 to 426. Could we play in succession, please? NGPF 304748, NGPF 304749, NGPF 304751, and then NGPF 304752, please.
Foxtrot 418. Go ahead. Apologies, just a little bit of a catch-up for me. Are we any further identifying the suspects, etc.? No, thank you.
I don't know if you picked up, there has been a call where someone's got video footage of it and video footage of the offender. So if you're going to be making themselves known to cops at the scene with that footage.
Yeah, that's what I've seen. I'll try and get some kit back in my car and try and find out who that person is. Foxtrot 41 to 48.
So,
Mate, everything's covered off at the scene. If you can just make sure you're area searching for that offender, maybe, like you said, we can get an image of him. The only information I've got, but is it's Ilkeston Road back up towards City.
yes, buddy, we're going to kind of go top 10, kind of surface and that.
is a fair reading of your messages at this point in time that you were quite persistent in trying to establish where the perpetrator was?
Yes.
What, at this stage, so we're now 4 to 6 minutes after even the air ambulance has arrived, what was your view at that stage of the efforts in respect of the search that were being carried out by the force control room so far as you were aware?
I knew that a search was being conducted. I knew there was a number of officers doing that. I wouldn't have known who was coordinating that search. I would have expected that that was being coordinated by a dispatcher with a supervisor overseeing that within the control room.
And when you say a supervisor, the force, the Detective Inspector Mather or somebody else?
Either the FIM or the fizzers that were in there at the time.
So either Detective Inspector Mather or the two that are slightly below him?
Yes.
And were you aware of that happening, in fact?
I wouldn't have been aware of it. Nobody would have told me directly. It was something that I would expect to be happening. As in, when we area search for offenders, it is what I would expect it to be coordinated, i.e. somebody is asking for what streets are being covered and noting those down, or somebody's telling somebody to go to this area and you go to this area.
And we spoke earlier about other incidents, other serious incidents that you've been involved in around the country.
Yes.
Is that your experience of how it is generally done?
Yes.
In terms of the descriptions, we've heard that your description over the radio there about going down, I think it was Ilkeston Road towards the city.
Yes.
Do you feel that you had enough information at that stage? Do you feel that enough information was being passed to you at that stage?
I believe that was the only information that was available at that time. That I asked for an update and I wasn't given any further information, so that was the last piece of information I was aware of VC, and I think that was prior to me going into number 316.
And have you subsequently heard about reference to Hopedale?
I have, yes.
And were you aware of that at the time?
No, at no point.
And would that information have been useful to you had it been passed?
Yes.
Could we please bring onto screen paragraphs 34 and 35 of your statement? It's page 16 and into page 17. You say at paragraph 34, in relation to the area search for the offender, I do not know who had overall control of it. I was committed at the scene for a period. I do believe that if it had been a firearms deployment, the FIM and I would have had control of the search, and it would have been run on a single channel, our firearms channel, and I would have requested that other officers/teams would have been patched into our talk group. The first thing I would have asked for would have been for the CCTV checks to be completed, drone assistance, and the National Police Air Service. Over the page, please. And you say areas would have been designated for officers to search so as not to duplicate and cover a greater area. And that's the evidence you've just given.
Yes.
Am I right to understand, first, CCTV checks? Do you mean from the local authority, from local premises, or what exactly do you mean there?
Both. I'd expect for, obviously Nottinghamshire's covered in a lot of council CCTV. I'd expect that those are being monitored and lifetime feeds or lifetime updates being given by those operators in the Nottingham Council. I know I've been in that building before, and I know they have a lot of cameras. I'd also, obviously you've highlighted Hopedale Close. One of the things, when we're on an armed deployment, we don't want to get too much in investigation, but we have to start somewhere. So if Hopedale Close was the starting point for the armed area search to be conducted, I'd be trying to identify CCTV on residential buildings, private dwellings, or doorbell footage to give a direction of travel, because then that would assist as to where to potentially go next. The one point with an area search is it's very hard to cover off an urban area completely unless you've got hundreds of officers to be able to put them at a stationary position to make sure somebody doesn't either pop out from a hiding point or come back on you because of alleyways, etc., or even if somebody was to jump over gardens. So the biggest probably asset for me with doing an area search as well as CCTV would be the National Police Air Service.
Have you heard of difficulties with the National Police Air Service and a difficulty in obtaining their assistance during the night?
Yes, I know that from previous years gone by, their hours have been cut down. I don't know if that's a national problem or if it's down to funding between different forces, etc. I would probably think it's the latter, that some forces only pay for it between certain times because of their what is deemed as the core hours of when most incidents occur. However, on that, it is still possible to get a helicopter or a fixed-winged aircraft if they're available if you don't pay for them as a force. That would be a conversation between the FIM or a supervisor in the control room to that force area or the National Police Air Service, and then whatever monetary cost it is would have to be sorted out later down the line, obviously if there's a major incident occurring then.
And is that something, again, that you've experienced working for another force in a different area?
Yes, recently in Derbyshire.
Thank you. You've also mentioned drone assistance.
Yes.
Are you aware that a drone wasn't in fact up and viewing the area?
No, I would expect a drone to be up and flying. I know that in Nottinghamshire the drone capability was very good. When I've had firearms deployments at night time, the drone has been there to assist, and it's an invaluable service.
And then the designated areas to search to avoid duplication. Looking to the future and looking to recommendations, yes. Is there guidance somewhere? Is there some sort of formal training or instruction that would assist in identifying how to search in that way?
I'm not aware of any, no. Like I say, it goes down to previous experience. I've obviously been in the police now for 25 years. I would common sense approach to it. Maybe not everybody thinks the same way, but for me, on an armed deployment, I would utilise unarmed staff for it, maximise the numbers. So I would position an ARV, one ARV to particular areas, and to be supported by unarmed staff with a stay safe briefing to those unarmed.
And do you physically get out a map or get a map up on your screen to segment the area?
Yeah, so it depends what force you're in and to what technology you have. I believe when I was in Nottinghamshire at that time, we'd have laptops and mobile phones, so it's quite easy to bring up a mapping system. Other forces have systems such as Airbox. That's on firearms cars where you could actually draw on a map exactly what area you wanted those officers to patrol. Obviously, it wouldn't go out to the unarmed, but you could just basically say, between these 4 roads, that is your square area. I don't want you to deviate out of those. That is, for the next 15 minutes, those are the areas that you will deal with. And then if there wasn't anything found, that area would then have to be broadened out. It would depend how far you would go on the time scale, and then maybe you would bring it back in again.
Thank you. I only have 2 small topics to follow. The first is the return to base.
Yes.
We've seen the maps where there's travel northwards, 5:15 to 5:30 onwards. All 3 of the ARVs yes. go northwards. Did that, in your view, leave the city centre vulnerable?
I wouldn't say vulnerable. There's only 3 armed response vehicles, and they're having to cover the whole county in Nottinghamshire. The reasons why we were going back at that time is, first of all, I would have notified the control room to make sure there weren't any other taskings for us, because that, to me, with the timeline and the mapping that I've seen, looks like it's a coordinated move back to HQ. I had several reasons for that. Is the Foxtrot 48 call sign was the call sign that was covering the north of the county, and I hadn't been told not to cover that area. HQ gives us a central location where we can respond to anywhere within the whole of Nottinghamshire within a reasonable time and back to the city. There was 2 medic kits that needed replenishing due to them being left at the scene, and I wanted those replaced should there be an armed deployment or another incident that we should go to. I also had 3 authorised firearms officers that were covered in blood due to the medical treatment that they provided, and I hadn't had the opportunity to speak with PC Graham or PS Hallam, and I wanted to check on their welfare.
And looking back, though, that's only, say, an hour and a half after the attacks themselves. Do you think it would have been helpful to have had another ARV in the city centre at all times?
Yes, potentially. I wouldn't say it wouldn't. Would I change what I did on that night? I don't think so at that particular time. Would I love to have more armed response vehicles and AFOs? Absolutely. I think 3 armed response vehicles to cover any county is a very low number. And to be able to perform to the best of our abilities, you would need more firearms officers.
Thank you. And then to move on to the topic of the debriefs, we've seen what you've included in your witness statement, your debrief to PC Wilkinson on the radio that morning.
Yes.
That's at paragraphs 46 to 48 of your statement. We don't need to go back to them. At paragraph 47 of your statement, actually, if we could bring paragraph 47 up onto screen, that can shortcut my question. It's page 21, the bottom of page 21. You say, at some point between the initial stabbings and Operation Plato being declared, my team and I all raised our frustration to each other about there being no authority to arm initially granted, and I stated this to PC Wilkinson. You've said all raised. What was your recollection about whether the views you've expressed today were shared by others?
I believe I had you call it a point-to-point, so a private radio call. I can't remember what officer it was that I had the conversation with, but it was that they had the frustration that there was no authority in place. The same with PC Goddard, who I was crewed with. We had the same conversation. I think that's captured on my body-worn camera when PC Goddard's viewed some body-worn footage. And I think I think the frustration was at that point when he's viewed the CCTV and described it as a frenzied attack. That's been passed back up again, because it was my belief that with that information, again, it's changed from the initial report that it would provide more information for the armed deployment.
And the views that you've given today in terms of the search and the assistance that would have provided, was that discussed at this stage?
No, I don't think it was, no.
So it was more the simple question of armed authority or not armed authority?
Yeah, because it was the frustration because of everything that comes with it. I think the biggest factor is that we do that job because we want not only to maximise or minimise the risk to the public, but it's also protecting our colleagues, other agencies and ourselves. We get put into a very vulnerable position as armed firearms officers. Should we be deployed to instances where we have to self-authorise, we don't have all our equipment, our less lethal equipment available to us. So it's more likely that we would potentially take a lethal shot than a less lethal shot if we're not at the authority stage.
And I'll just take you to the debrief document. Very final questions. NGPF 307689, this is the formal debrief.
Yes.
Do you remember being told whether it was going to be formally recorded or not?
Recorded in what way, sorry?
Taped or...
Well, my recollection is that it was, or I was told it was audio recorded. I knew that there was somebody in there taking notes as well. It might just be that I've got that wrong. I'm used to, particularly firearms briefings for a planned job are always recorded.
Are they usually recorded, this kind of a debrief?
I would probably say so, yes.
If we could please go over the page to page 2. I'm just going to read to you the top entries. Chief Inspector Mather says, remember a challenge, priority at this point was towards first aid and victim. And then you say, requested the consideration for armed authority based on multiple stab wounds when confirmed as second victim. Victim is priority even if it's a firearms job. Challenge around victim being the priority, but in a firearms job, there's priority on the victim. And then asked to expand. Initial assessment was multiple stab wounds. For me, it's spinning the wheel, otherwise so dangerous description with unknown intent. Can you assist us with what you were saying there?
Yeah, so as I say, I'm not a TFC. I know how TFCs work, and we all work to the same NDM, to the National Decision Making Model. As I say, we work around information and intelligence. The criteria to be met is at a very low level, it's reason to suppose. So it's very low, and obviously the criteria points in there, 2 of them are somebody's otherwise so dangerous or has access to a lethal weapon. With this information that was being provided, as I stated previously, that somebody had been stabbed and now it was multiple stab wounds, and then there are now 2 victims, multiple stab wounds. I believed it was just adding to the information that there should have been an armed deployment. With regards to the victims being the priority, obviously the information intelligence that we have, the TFC, if deploying for an armed deployment, would build a threat assessment and a working strategy. In this instance, the victims would have been at the top of that working strategy, and our driving actions would have been to preserve life. Like I've said, I don't disagree. We're there to preserve life and protect life. We should have been providing medical aid to those, as well as doing the other things that we can do as firearms officers.
And is that because protection of life doesn't just include the protection of the lives of those at the scene, but also the potential threats posed to other people's lives?
Yes. So with regards to that, and it comes back to a statement a few moments ago, is that having the armed authority means that we have access to all of our equipment straight away. Our equipment is kept in a gun safe, which is between the 2 front seats on the back seat, so it's within easy reach, but it takes time to get to that equipment. Nottinghamshire at the time, with their carbines, weren't made ready, and what I mean by that is there is a magazine loaded into the carbine, but the action on the weapon isn't racked, so there isn't a round within the chamber. So even if you do grab your gun, you have to make it ready. So by being at the armed authority, that process would have happened, and you would have been able to respond to anything should it appear directly in front of you, or a member of the public was reporting something, or another colleague had a sighting of VC. There just wouldn't have been a time delay.
And just very finally, the part in bold, general discussion on armed authority with contributions from OFC and TFCs, each describing their national decision models. Are we to understand that that is summarising something controversial? Was there a dispute at that point in time?
There was definitely a difference of opinion. I can't remember exactly what was said. I know that, obviously, as I've alluded to already, I've said that the armed criteria was met. Just because we're giving medical attention, somebody doesn't mean that we don't need to have that authority. We can deploy still. We do regular exercises where either in training we turn up to a victim that we give medical aid to, or some or we come across somebody as part of the exercise. There was other parts to the rationale in that debrief that I disagreed with as well.
Very briefly, what were those?
There was, in relation to, I think it was when I was leaving the scene, the FIM said that he didn't want to put on an armed authority because he thought he would lose the number of officers he already had searching, as in the unarmed, to which I said, that isn't the case, you would just simply give them a stay-safe briefing, i.e. I would say you are not to approach the subject, just give a description, observations, report back and guide the firearms officers and they will deal with that individual.
Did you have specific concerns about his capability?
I wouldn't say I had concerns about his capability. I thought in that debrief that the point that he made with regards to losing the unarmed assets was wrong.
Thank you. I don't have any further questions. There are some questions, I think, from Ms. Cartwright.
Yes, thank you. Mr Maloney, you're not asking any questions. Ms Cartwright, thank you.
Officer Speeding, first of all, on behalf of the survivors, can we thank you for your efforts on the night, but also for the evidence you provided in your witness statement.
Thank you.
Now, you've just made clear that you had essentially a rationale provided by the FIM to you at the debrief that he thought if he'd given you armed authority, it meant he would have lost his unarmed asset on the search. And I think you've rightly said, your view is that would not have been the case.
That's correct.
And essentially, if you'd have been given all the authority and effectively been able to truly perform your role as the OFC, would it have been that you would have given exactly that stay-safe briefing to the unarmed assets? You'd have been able to direct them, but effectively stay in your vehicles, don't get out, don't approach.
Yeah, so the stay-safe briefing should be given by the TFC. However, on occasions, I have reiterated that stay safe when I've been on armed deployments, whether it's immediately after the TFC or in due course, just to make sure that unarmed assets are aware of their roles and responsibilities, because I wouldn't want anybody, any colleague putting themselves in harm's way when we've got the equipment to deal with somebody that is dangerous.
Thank you. Now, you've given evidence that even before getting to the scene, you had believed that the threshold for an armed authority had been met.
I asked to be confirmed whether or not an authority was being considered on the initial reporting. I did question it on arrival at the scene, yes.
But I think, is it right, when you saw the severity of the attack, that's when you were clear that the reason to suppose threshold was certainly met by what you saw at scene?
Yes. And
perhaps if we just briefly display that, it's your paragraph 22, please, which is WITN 04070001. Paragraph 22. Thank you. Paragraph 22, please. Sorry, it's page 12. Thank you. And I think you've recorded it there that someone's in possession of or has immediate access to a potentially lethal weapon is otherwise so dangerous that the deployment of armed officers is considered to be appropriate and as an operational contingency based on the threat assessment. And I think what you had said effectively, which is captured in the vehicle later on that morning, is that your concern was this was a highly dangerous individual, this was a stranger attack, and he was going to do it again.
Yeah, I didn't know that it was a stranger attack. However, it's not an everyday occurrence to go to something like that, especially two people within close proximity and to have that amount of injuries to them. And yes, I did deem the person as dangerous.
Yeah. I'm sorry, the reason why I said that, because that's what's captured that you said later on that morning on your body-worn footage, that was your concern. So it was reference to your belief that this was could have been a stranger attack.
Yeah, so, yeah, and I will confirm that, is that, and I did say those words, you're quite right, is that I thought it was very strange for something to have happened there to what I saw as two young individuals. And just due to the nature of it, I had concerns that if it's happened there, why couldn't it happen somewhere else?
Yeah. And in fact, that's what we know happened. VC attacked Ian and then used that vehicle to inflict further injuries to those that I represent and march in.
Yes.
And so you've said, I want to ask you, the footage was just played at the request you made again at 4:24. One of the things that's fed back is that Oscar 1 was listening, so the FIM was listening, but it doesn't seem that you actually got a response to the request you were making at 4:24 in respect of, excuse me, for an update in the developments. I think we can hear Oscar 1 is listening, but you don't actually have a response to what you're asking from control at that point. Can you recall that?
Is that the response that I just got back? No, nothing.
Yes.
Yeah, so that I just took that as they haven't, or the control room haven't got any further information for me. There's nothing further known on VC.
But I think what's now accepted has been accepted by Officer Allardyce, that when you were asking for further information, it was known that VC had headed towards the direction of Hopedale Close.
Yes, that's correct.
But also there was a description of him.
Yes.
Would you agree that if you'd been given authority, a firearms authority, as the OFC, you could have, as soon as you were able to be released and your colleagues to be released, you would have then set about that strategic search in that direction?
Yes, that would have been the starting point. I know that dog handlers have gone to that area already, but that would have been the first starting point.
Yeah, and you've been obviously updated by Mr. Blake that a drone wasn't put up.
Yes.
But drones were available that night, and in fact a drone had gone towards the cathedral end. But would you have been immediately requesting drones to be at your service tactically to assist in the search?
Yes, so in Nottinghamshire at that time, drone officers would be attached to a firearms deployment.
Yeah, and so that additionally would have given you that 360 view of whether there was a black male matching that description and where he'd gone.
Yes, or any heat sources that could be hiding anywhere.
All right. And so would you agree there would at least have been a realistic prospect, even as early as 4:24, of you then finding VC?
I'd love to be able to say yes, but with a lot of searches that I've done before, it can't be guaranteed that you're going to find somebody. Like I've already stated, searching in an urban environment is very difficult, but the earlier you get out searching for somebody, the more chance you have to locate them, and the more equipment that's used, i.e. the drone that you're alluding to there, the more chance that you've got.
And I think you've also said you'd have also been asking for real-time information from the CCTV cameras as well.
Yes, that's basic work.
And then can I ask you about that? Because certainly it's not just a firearm authority gives you an ability to discharge lethal weapon, but it also gives you the input of the Strategic Firearm Commander, the Gold Command, the TFC, but also a tactical advisor. Would you agree?
Yes, absolutely. It creates a command chain.
It is. And so essentially it's a bespoke command chain that was then giving you a bespoke information and intelligence through a dedicated line that's not distracting you from anything else.
Yes.
And that's the significance also that was missed here, would you agree, when no authority was given for firearms?
Yes, I think it gives you that very deliberate command structure, and it's there for a reason. That I think I always say that, not that the general policing isn't professional, but I would allude to firearms. The firearms world is very professional in the way that we know that when we're deployed, we do things in a certain way, and they're very methodical.
And I think in terms of that, you're trained as well to work in teams, aren't you?
Yes.
And one of the trainings you've got is to essentially deploy as mobile armed support to surveillance. So you're used to operating tactically in an area as a team of 3 or 2 or whatever to most be efficient.
Yeah, not every officer is trained in that world with the surveillance. You obviously have to do extra courses, but we work as a team. That is what the armed world is. We armed deployments are always about working in a team, and that would be working with dogs as well. They would be part of our assets.
So again, you've already told me about drones, CCTV, but also you would have utilised the available dogs that were there that night.
Yes.
And again, would that have been assisted by the tactical advisors as well as to how those tactics could have been utilised?
Yes, the tactical advisor is there to give tactical advice to the TFC. They will give the advice to the TFC as to whether the tactics that have been authorised would meet their working strategy.
Thank you. Now, you've given your view already that 3 armed response vehicles at that time of the night in any event is an incredibly low number.
Yes.
But if you've made the decision to deploy armed officers to provide that first aid, there's the concerns about contamination, would you agree?
Yes.
And so, essentially, by asking firearms officers to take the lead on first aid, it's then almost limited the utilisation of those other armed response officers, would you agree?
To an extent, yes. However, I think I'd be sat here now with people questioning me or my officers if we didn't go to the victims and provide medical treatment.
No, I agree with that. But why I'm asking that is because that should have been then in the FIM's mind about what other resources might be needed to bring in those that are about to parade on to be the next armed response officers, or even making a request of those nearby forces for who they had by way of armed response that could come into the county. Would you agree?
Yes, so there wouldn't have been any other firearms officers coming on duty until 7 o'clock that morning within Nottinghamshire. However, obviously nearby forces, you could have requested mutual aid for them to deploy to the area.
Thank you. Now, you've been asked questions about not going into the city. So essentially all 3 went back because of, I think you've described the they needed to clean up effectively the officers that assisted with first aid.
Yes.
You'd not assisted in first aid at the scene, is that correct?
That is correct. Oh, very slightly. When we first arrived there, I took the medic bag down to PS Hallam, who was providing medical attention to Grace. So there was the possibility I could have had contamination on me. My medical attention treatment was handing out equipment, so it was very limited. However, I'd been in the car with PC Goddard, so the likelihood of cross-contamination could have been there.
Yeah, but what I'm saying is the suggestion had been given that all of the armed response officers at scene on Ilkeston Road were engaged in providing first aid.
Yes.
But that's not factually what occurred, is it?
No, I wouldn't say that I was providing medical attention or provided medical equipment, but I didn't, from an OFC point of view, although I wasn't an armed authority, I didn't want to get tied into that because I knew there was other things to do, especially with number 316. I never had got tied up in the medical attention, treatment, and an armed authority had been given. It wouldn't have been the best place for me to then take on the information.
And I think we know from what's captured on your body-worn footage that you assisted with the entry equipment to enter 314, I think, from the back.
316.
316, yes. I do apologise. But again, in the overview statement that was given as to the chronology, there was no detailing about your involvement with that. And from your perspective, you'd not asked anyone not to deal with what you were factually doing at the scene, had you?
No.
And so are you able to assist as to why that wasn't being dealt with, as to what you actually did do at Ilkeston Road?
I can't answer that. I don't know why.
Now, if you'd have been told, and I think you've said as you drove in, the you'd headed in where what you'd heard about the suspect heading towards the city, and so you'd had a view as you drove towards Ilkeston Road.
Yes.
But if you'd been told that there was information about the suspect had made off to Hopedale Drive, could that have affected how you drove back to base that morning? Because certainly we can see that all three essentially do a straight parade back up the main road. And I'm just wondering whether in that scenario it's likely that you would have also perhaps looked as you headed back to base in the area. Because perhaps to give a context, we know ironically that at the time all three armed response officers were passing near to Mapley Road, and Magdala Drive was very, very proximate in time to when Ian Coates was killed.
I don't think at the time of going back to HQ it would have changed the direction. I think it would have changed the direction earlier of armed officers or any officer that wasn't aware of that location. It definitely would have been a consideration for myself. I don't know what time that information was passed with regards to Hopedale Close.
419, I think. It's
okay, so that was when I was going into number 316. So it would have definitely changed the search area at that time. An hour later, I don't know without any further information being passed as direction of travel, etc.
Okay. And then can I ask you, because we know you all paraded back and Mr. Blake's asked you about whether that left the city exposed, bearing in mind the intelligence you knew was that the suspect was heading towards the city. There is a policy that suggests that there should be an armed response vehicle in the location of the city centre, and the policy also suggests that almost there should be care when there's handover to almost that person not parade off till they know the armed response officers coming back from headquarters. Were you aware of that?
Aware of that policy. It's not quite as clear as the handing over from car to car. That just doesn't work, especially on a night shift. So cars would return back to HQ on a night shift, maybe naturally around 6:15 to make sure all equipment's checked, any paperwork that's done from incidents that you've attended is updated, body-worn footage is downloaded, etc. So on a night shift, there is always a gap with regards to the city centre. And like I say, with 3 cars, you're trying to service the whole of the county. And quite often, a ARV for the city would be pulled out of the city. It wouldn't literally just be parked somewhere.
And so would you agree, though, that should have been a factor that the FIM was considering in respect of resources and resources needed for the city?
Absolutely. It could be a consideration, definitely.
Now,
you to be much longer, this country.
No, just one matter. So you clearly detail the importance of a working strategy and a threat assessment, because particularly when you're authority, that's really the briefing you're being given to inform you as to whether to discharge lethal force.
Yes.
And so would you agree that they need to be accurate and have the fullest possible information to equip the firearms officers or you as the OFC with all the relevant information to make those life and death decisions?
Yes, in best practice, some circumstances, if it's a condensed briefing, there might not be the opportunity to provide that. Likewise, in excuse me, in some situations, because I'm an experienced OFC, from information I've been given, I will sometimes know what order that threat assessment's going to be in, and like I say, if there's not the time, I would rather a tactic to be given by the TFC. However, if there is the time to provide that, then yes, I would expect as much information to be given as possibly could.
And we know that late at 6:34 in the morning, a briefing was given to the armed officers. Were you off duty at that point, or going off duty?
6:34 on the 13th?
Yes.
No, I was on duty till past midday, I think.
Right. So we've got now the recording of the threat and risk assessment that was given at that time, which for reasons of time, I'm not going to go with the factual details, but it admitted some key factual information about what was known at that time. But also in respect of the threat assessment and working strategy, Officer Mather just said this: I'm not going to go through a proper threat assessment and working strategy, but I want them to sustain public protection. The criteria for arming is met and all tactics are available to you subject to my authorisation. Would you agree that that, in terms of the having then been time at this point, is not in any way a threat assessment or a working strategy?
Yes, I'd agree with that. I think the difference with that job that morning was that the believed one subject at that time had already been detained. So to try and put out a working strategy, or a threat assessment, a working strategy at that time around a full briefing, potentially might have been very strange. I understood what the TFC was meaning, is that we're under the Op Plato umbrella at that time, and that any tactic could possibly be in because anything could develop. I would have expected, should there been specific information to potentially another offender, that a full working threat assessment and working strategy, along with a brief into the specific tactics that we needed to employ, would have been given.
And would you agree, as well as factual accuracy about what had occurred up to that point by way of the incident and what was known about the suspect?
Sorry, just...
But as well, the factual, for time I'm not reading all the passage. So
right.
we've got so what is being provided is, it says the suspect's 50. It doesn't deal in any way with the attack on Mr. Coates. It doesn't reference the 2 locations of the attacks that had occurred to the survivors.
Yes.
So there's factual inaccuracies and incomplete information that forms part of that briefing.
Yeah, so if somebody was on that briefing that hadn't been there for the entirety of that evening, like I had, those would be poignant parts that are missing for those individuals, yes.
Thank you. And then just finally, you obviously were making a recommendation and asking for armed authority on a number of occasions.
Yes.
Before it was granted after the Op Plato. But certainly the APP suggests if a recommendation for armed authority is declined, the rationale for that should also be recorded. Would you agree with that?
Yeah, I would expect it to be recorded somewhere.
And for your reference, I won't take the time, ma'am, it's NGPF 001-6086 at page 68.
I think we've seen it before, haven't we?
Pardon?
We've seen it before.
I think, yeah, thank you. Thank you again, officer.
Yeah, thank you.
Yes, Mr. Beggs.
Officer, you arrived with PC Goddard at 4:12.
Yes.
And as you mentioned to previous counsel, the first thing you did was provide assistance to Sergeant Hallam, who was dealing with Grace.
Yes.
And I think you gave him chest seals, amongst other things.
Yes.
And you then observed Sergeant Hallam, an ARV officer, and PC Goddard, your colleague, working together on Grace with their enhanced equipment.
Yes.
And you, in fact, got the oxygen tank and the defibrillator from your vehicle.
Yes, that's correct.
And your colleague, John Goddard, used both of those pieces of equipment.
Yes.
And they are bits of equipment that response officers simply don't have.
Yes, that's correct.
And this is fair, isn't it? Even after the paramedics arrived, the ARV officers, not yourself, but Goddard, Hallam and Graham, were still actively involved in first aid, weren't they?
Yes.
And in fact, Sergeant Hallam and PC Goddard were continuing with CPR on Grace until she was lifted into the ambulance.
Yes.
And likewise, PC Graham, in relation to Barney, was actively involved in managing his airway, wasn't she?
Yes.
And your activity was the method of entry equipment which you retrieved from your vehicle.
Yes, that's correct.
And it was you that managed to effect the entry to number 316, wasn't it?
Yes.
And it was obvious to you that number 316 had to be entered
Yes, absolutely.
Because either a suspect or a perpetrator could be present.
Yes.
And only you effectively were able to do that. That's fair, isn't it?
Yes, due to the equipment that we carry on our vehicles.
And you finished that essential task and were back at your vehicle at 4:25.
Yes.
And we know that at about 5:15, give or take a few minutes, you in common with the other 3 ARVs were travelling north to HQ.
Yes.
Can you help the chair with your activity between 04:25 as you return with your ripsaw and 5:15, please?
There's a long time frame there. So part of it was having 360 awareness on Ilkeston Road, because I was conscious of the threat that was that could potentially appear from either alleyways, behind walls, or out of a building. I was trying to take on as much information as I possibly could by looking at the incident log on my laptop. Information was quite hard to fully process due to all the different channels on the airwaves that were being used.
Did you search during that period?
Yes.
With PC Goddard?
Yes.
So you self-deployed to search?
Yes.
Yes. And can you help us, we can probably get it from the body worn, but can you help us approximately what time you self-deployed to the search?
I wouldn't know without having a body-worn camera to look at, I'm afraid.
Thank you. You know, don't you, that when your colleague PC Bauer in fact arrested VC, he had a sidearm on him, but he actually used a taser, didn't he?
Yes.
Yes, officer, thank you very much indeed.
Thank you.
Thank you. Just one question, officer. We heard from Superintendent Allardyce, who'd reviewed all of this case, that to find one stab victim who was female was quite rare, and to find 2 together in the way that they were found in this instance was a very rare situation. Was that your view as well?
Yes.
And did that, in your view, affect your requests for armed authority?
It heightened my senses, should we say, that it was strange, but it wasn't just because of that. I requested the authority because the injuries that were quite visible and reported were of that serious of nature that I deemed that the authority was the best way to maximise and safely
Gave you
minimise
options
them.
if something had
Absolutely,
happened.
yes.
Yes.
That's what we're there for.
Yes, thank you. All right, thank you very much.
Thank you, Chair. Just before we finish, we heard earlier today from Ms. Draper of Mighty. There are 2 further statements. I'm just going to read their URNs into the record.
Yes.
It is Kat Jackins, and that is WITN 0072001, and Kirsty Crowley, that's WITN 0070001. Those will go up on the website alongside the other statements from today.
Thank you, Mr. Blake. Thank you, officer.
Thank you.
So we'll start again tomorrow morning, 10 o'clock. Thank you.